All persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please come to order.
All right, good morning and welcome to the District of Columbia Court of Appeals for our virtual oral arguments this morning. We have 3 cases before the court today for argument. I'm joined this morning by Judge Kate Easterly and Judge Roy McLeese. The first matter is in re MOHAMED ALAMGIR. Are the parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
All right, Mr. Link, I believe on behalf of disciplinary counsel, you will argue first.
Yes, Your Honor. If it pleases the court, my name is Miles Link. I'm here on behalf of the Office of Disciplinary Counsel. Mr. ALAMGIR has filed a petition for reinstatement to the bar. He was disbarred by consent in 2004. Disciplinary counsel notes at the outset that on the same facts presented in his petition here, he presented it to the Supreme Court of Pennsylvania, which also disbarred him in 2004, and the Supreme Court of Pennsylvania denied his petition for reinstatement. We urge this court to do the same. The undisputed facts in this case, Mr. ALAMGIR engaged in a fraudulent labor certification application and immigration scheme for a period of about 7 years, at least 7 years, in which he filed at least 259 fraudulent applications on behalf of his clients. As a result of this scheme, he netted $2.75 million. He was convicted and pled guilty to 164 felonies, including 100. Yes, ma'am.
Could I interrupt briefly just to ask you a threshold question about whether the Rule 14G affidavit by Mr. ALAMGIR is whether we should give deference to the board's view that it was sufficient under our rules to trigger the 5-year process, and therefore whether the case is before us properly at this juncture.
Chief Judge Blackburn-Rigsby, that is one of the 3 grounds upon which this court can deny this petition. Petitioner did not file his Rule 11 Section 14G affidavit with the board until November 26 of 2019. That petition was deficient and he had to refile it on January 20th, 2020, and he did not file it with the court until March 12th, 2020. Clearly, the 5 years has not run. Now, it's interesting. The board found that an unsworn, unfiled letter that he mailed to disciplinary counsel in 2011 should be considered as his sworn, filed with the court affidavit, which Rule 14G requires. Disciplinary counsel takes the view that that finding by the board is, with respect, absurd. A sworn statement, a sworn affidavit upon which is filed under penalty of perjury is absolutely different from an unfiled letter sent to the Office of Disciplinary Counsel. The board said that the rule doesn't specify the address to which the letter can be sent. Mr. ALAMGIR was represented by counsel in his disciplinary proceedings. He was represented by counsel. He received the court's order of his disbarment. To suggest that in light of that, a letter can be sent willy-nilly hither and yon without complying with the rules, without being sworn under oath, that is not what Rule 14G, Section 14G requires.
Well,
this is not a mere technicality.
Well, obviously, counsel, it's not what the rule requires, and the board certainly recognized that. The question is when, what kinds of non-compliance can be excused, and if so, when? And let me just ask you a hypothetical that relates to, I think, one of the positions that the disciplinary seemed to take in its brief. So imagine that I'm disbarred and I am represented by a lawyer, and my lawyer, and I'm a former lawyer, I guess, and I look at the rules and I realize I need to file a sworn affidavit, and I execute one, and my lawyer says, okay, I'm going to go and send it. And my lawyer never sends it. tells me he did. So no letter is received, but I've sworn, I actually executed a document, but it just never got sent to anybody. I did what I was supposed to do. I guess I could have checked with the board or the court to make sure it was sent. Would you say, because I thought in your brief there was a suggestion that if no sworn document is received by the board and the court, or at least or the court, there's just no there's no coming back from that relative to kind of non-proton treatment. Is that your view? So in a hypothetical like I just described, you think because there was no filing, even though there's a pretty good excuse, not so clear that's true here, but even though there's a pretty good excuse about how that happened, you would say, nope, it's just a categorical requirement. There has to actually have been an affidavit that was filed and with the board and the court.
Thank you, Judge McLeese. I would argue your hypothetical presents a very interesting fact pattern. If the lawyer, for example, who was supposed to have filed the affidavit submits his own statement to the court in conjunction with the client's statement, confirming that, yes, the client sent me the affidavit, it was signed, it was notarized, and I simply forgot to file it, I committed error, and I, that would be strong evidence, I think, to weigh on behalf of the client that, in fact, from the respondent, the petitioner's perspective, everything had been done that should have been done. And so I think there you'd have a much stronger case for granting nunc-pro-tunc treatment to a late filed affidavit. Here, note, we don't even have an affidavit that was filed in 2011. We have an unsworn letter. So that element, which was in your hypothetical, doesn't apply. In your hypothetical, the affidavit was prepared, it just wasn't filed. Here, we never had an affidavit prepared. And the first affidavit that was filed in November of 2019 was deficient. It had to be withdrawn and refiled with the board in January 2020 with the court.
What was the deficiency, and what was the specific deficiency that you're referring to in the 2019 version?
Your Honor, I do not have that information before me. What I do have is that the affidavit had to be amended and it was refiled in January of 2020. So,
and in this instance, what was the explanation for the non-compliance for 8 or 9 years with 14G?
The petitioner testified that he did not file an affidavit back in 2011, or really within 10 days of the court's order in 2004, which is what the rule requires, upon advice of counsel. There's no indication who gave this advice. There's no confirming statement by his counsel that that is what happened. There's no indication who that counsel, I mean, with respect, there's no basis to support that conclusory and very vague justification that the petitioner has made to support that allegation.
Did the board make a finding that that testimony was true, or did it just not really think it mattered what the explanation was, as far as you can tell?
As far as I can tell, Your Honor, I think the board basically took the view that if the letter was filed, for whatever reason, it should be given nunc-pro-tunc treatment, despite the fact that it was an unsworn statement. I think the board's view was
just about I asked you a compound question, so it's on me. Let me cut out half of it and say, with respect to the testimony, Mr. ALAMGIR, that he didn't file a contemporaneous Rule 14G affidavit on advice of counsel, which I think was focused on the 2004 period, if I'm recalling correctly. Did the board make a finding about whether that was whether it chose to credit that testimony, or did it just not really make a finding about whether that testimony was truthful one way or the other?
Your Honor, it's my understanding the board did not make a conclusive finding as to that testimony, but again, I do not have the board's decision in front of me, but that is my understanding. So it's our understanding that as a matter of law, this petition is untimely filed. 5 years has not elapsed since the 14G affidavit has been filed, and therefore the petition should be dismissed on that ground. If the court, however, chooses not to dismiss the petition on that ground, there are two other grounds upon which the petition can be dismissed. First, it is our responsibility to the court to advise it in our brief, as we've done, that this case presents the court with the opportunity to address an issue that was expressly left open in the Borders and Moore cases, and that is whether some misconduct is so serious as to permanently preclude reinstatement. Here, applying the first prong of the Roundtree test, petitioner's misconduct is virtually insurmountable. He systematically betrayed the United States government's system of immigration law, his professional obligations to his clients, the public's trust, the legal profession, his employees, his friends, and his family. Pursuant to the In re Lipari and In re Bonds cases, each and all of petitioner's 164 convictions involved crimes of moral turpitude, to wit, conspiracy to defraud the United States, labor certification fraud, immigration fraud, and money laundering. In addition to the hundreds of fraudulent documents he filed, he also counseled at least 95 clients to lie in their immigration interviews, conduct that would have resulted in disbarment in each instance pursuant to In re Corrisi. So,
Mr. Link, no doubt respondent's misconduct that led to his disbarment was egregious. That's why he got disbarred. I guess the question is, can he be rehabilitated from that, right? Is there a reason to believe that categorically someone who perpetrates that fraud 15 years ago cannot be a better person and cannot have a bar license? And I'm not sure that reciting all the details of how bad the misconduct was 15 years ago is helpful in answering that question. I wonder what else you have to give us to support your categorical argument.
Thank you, Your Honor. The reason I recited that, if I may, is because if the categorical argument holds, then in fact, it's the weight and significance of those violations that would support a categorical finding. But if
I'm sorry, it's the weight and the significance or the nature?
My choice of words, the nature of those violations, the fact that they were crimes of moral turpitude, the fact that it lasted for 7 years, the fact, as the hearing committee itself found, it was done pursuant to absolute greed, the fact of the amount.
I want to make sure I understand the logic of your argument. This is following up on Judge Easter's question in a way, but maybe more abstractly. Assume if you're trying to explain to us why there should be a categorical bar in certain circumstances, no matter how the other Roundtree factors work, if as soon as we hear about the definition of this crime and the circumstances surrounding it, it just doesn't matter. There's no coming back from it, to use the phrase I used before in a different setting. Like, what's the logic of that? What's the theory behind that? If the idea, I mean, the contrary view is, there's always hope for redemption. Someone could do something no matter how horrible. And if you wait 20 years in between, you could be convinced that someone who did something very horrible previously is a changed person and is a good person and won't do anything bad again. And is your point that there's some crimes that are so bad that even if the person is rehabilitated, we shouldn't care. And we should say, if you did that, you're just out, even if you are rehabilitated? Or are you trying to say there's something about this crime or some crimes where you just no one could ever be rehabilitated if they did that? Which of those two things are you saying? Are you saying both? I'm just not quite sure I understand the logical structure of the, per se exclusion theory.
Thank you, Judge McLeese. And if the view is that the crime is so terrible that one could never recover from it because the impact of the criminal conduct, if the court didn't find that in the In re Moore case, then we understand the court may not want to find a categorical finding that just certain offenses a disbarred attorney can never be reinstated. On the other hand, we did think it was important to tee up for the court in this case, given the number of the felony convictions, given that the crimes were crimes of moral turpitude, and given, in our view, the lack of really remedial efforts by the client that this might be such a case. But if I
All
may,
this seems to go to sort of the third issue, right? Maybe that's where you're segueing.
that's a,
But just to tie the second issue off, I didn't really hear an answer to Judge McLeese's question, which I understand to be, is the rationale that just the crime itself is so bad that we don't care about rehabilitation, or that the crime is such that we think that in fact rehabilitation isn't possible, isn't real?
I would argue that in this case, we think the crime itself is so bad, the fraud on the government, the fraud perpetuated generally, the multiple acts of fraud, that rehabilitation is just illusory. And so therefore, this should not, this respondent, remember, the practice of law is a privilege, it's not a right. And we think this client has permanently foregone that privilege. But you're right, Judge Easterly, the third argument we're making is that he has not met his burden of proof to show by clear and convincing evidence that he has, in fact, made the case for reinstatement. And as this court noted in In re Foley, where the misconduct is practice related, the petitioner has an especially high burden to meet, and his evidence will be carefully scrutinized. Let's look at some of the evidence he says here. He says, for example, that when he was ordered by the US government to forfeit $2 million of the $2.75 million he earned from his fraudulent scheme, that the government accepted $682,000 in full satisfaction of that judgment. But there is no documentary evidence to support that claim. We have petitioner's vague testimony. There's a conclusory finding by the Pennsylvania Disciplinary Board in a report that was rejected by the Pennsylvania Supreme Court. There is no basis to.
I thought there was also a document that is a lien release document of some kind.
Well, Your Honor, it's a lien release document of some kind. What we don't have is a statement by the United States government that the forfeiture has been satisfied in full.
No, I understand. I was just responding to your statement that there was no documentary evidence. I thought there was. It may have its limits that you can point out, but I just wasn't sure that it was accurate to say there was no documentary evidence that tended to, connect to the assertion that he had fully satisfied his forfeiture obligation.
Well, we're not contesting that he paid the $682,000. The question is, did that fully satisfy the $2 million forfeiture judgment? He also has not.
There's a part of the forfeiture judgment and related documents that I found confusing. I wonder if you could help me on it. It seemed to me, at least potentially, that the documents were inconsistent about whether the forfeiture order was $2 million plus these 5 properties that may have been acquired with tainted funds, or whether it was $2 million and that the 5 properties could be, if they were sold, then their proceeds could be used to kind of pay off the $2 million. So is it $2 million with the properties being a way of possibly partially funding that $2 million that was forfeited, or do you think it was $2 million plus the 5 properties that was ordered forfeited? Do you know the answer to that? I found it confusing.
Your Honor, I found it confusing as well, and I would argue that it's petitioner's burden to clarify that confusion. It's petitioner's burden to show by clear and convincing evidence that he's met whatever obligation he has met. And we submit that the very lack of clarity in the evidence he presented shows that he has not met that burden by clear and convincing evidence. He also has not paid restitution to his victims, the clients who paid him exorbitant fees to submit fraudulent applications on their behalf. Such criminal misconduct is not legitimate legal services. They should, and petitioner should not benefit from the fraud. The DC Bar Client Security Fund advised petitioner in 2008 of a payment it had made to one of his former clients because of petitioner's dishonest conduct. That was in the Client Security Fund's notice to petitioner. Petitioner did not reimburse the fund for this award until 2019. after he had filed his petition for reinstatement and after the disciplinary counsel asked him for additional information regarding this client's claims. This ex post facto effort to sort of clean up the record while he makes his application is not evidence of rehabilitation, is not evidence of efforts by the petitioner to, in fact, recognize and ameliorate and satisfy his obligations. His character witnesses, he introduced 4 character witnesses. They did not know the extent or the nature of his crimes, and we're not suggesting that character witnesses need to know all of the specific details, but they were basically testifying that in their view, petitioner was a good guy. They had when they were cross-examined, they had no real indication of what it was he had been disbarred for, or in fact, what it was they were supposed to be testifying to. And we urge the court to review that testimony. Petitioner has said that his rehabilitation is reflected in the Bangladeshi organizations he's active in. He was active in many of these same organizations while he was perpetuating his fraud and his misconduct. And he used his contacts in these organizations to recruit clients to engage in the fraud and misconduct. We have no doubt that he is still and renewed his membership since he was released from prison in these organizations, but membership alone doesn't suggest that he's done anything there that would suggest a changed persona or a rehabilitated, someone who is rehabilitated enough to be restored to the privilege.
Why do you say membership alone? You make it sound like all that he put on about his involvement in these organizations was, I am a member, but I thought there was a fair bit of more detailed testimony of getting awards and the nature of what he did. And some of the same people were character witnesses went into some detail about the nature and extent of his activities. So why do you say mere membership?
Your Honor, yes, he did get awards. I did not mean to suggest he is not. There are many reasons why people get awards in membership in charitable organizations. As we all know, he had contributed money to these organizations. He certainly had made himself an important factor of these organizations. He'd assumed some leadership roles in some of these organizations. What had he done to address through his membership the immigration fraud and misconduct he had engaged in, which resulted in his incarceration and his disbarment? That's not in the record. So it's our view that the evidence petitioner has submitted, it does not meet his heavy burden of clear and convincing evidence to show that he is entitled to reinstatement to the bar.
Mr. Link, so I guess I'm wondering what would, had he paid back all $2 million to the penny and documented it, as opposed to proffered the explanations that he proffered for why he wasn't able to recoup all of the $2 million that was supposed to be paid in restitution. We don't see here in this record what we've seen in some other records where the hearing committee is really finding him lacking credibility on a lot of fronts or being untruthful on a lot of fronts, like we see in some other records. And so what, in 5 years, if he paid back the $2 million, that would be enough? If the, I guess what would be enough under the circumstances of this case to show fitness to continue to practice? He's taken CLEs, he works as a paralegal, he's staying active in the area of law he previously practiced. Would he need to change his area of practice of law so that you don't have the concern that perhaps immigration law is not an acceptable area based on his prior issues? What would it take? I mean, we do have an en banc case, McBride, where we've already said that we don't have a lifetime or a perpetual ban on reinstatement when someone is disbarred. So,
Thank you, Your Honor. I think one thing to start with would be in his testimony when he was asked about his former clients, staff, colleagues who had been, some of whom had been prosecuted, some of whom had been convicted of crimes related to his misconduct. He really testified he had no idea really what had happened to them. He had taken, in our view, no steps to ameliorate whatever harm they had suffered as a result of his misconduct. He did refer to the harm to his family, but his harm involved many, many more people than just his family. And we would, as a threshold, want to know what steps has the attorney taken, the former attorney taken, to address that, to ameliorate that, to compensate or relieve others for the burden his misconduct created. We have none of that in this case. The petitioner has said that he's taken some ethics courses and some other CLE courses. With respect, that is easily done. There's been no evidence as to what he has done with those courses. There's been no evidence that he has in fact absorbed the information those courses intend to impart. What disciplinary counsel does is look to the evidence that a petitioner presents. We don't suggest to petitioner you should do X or Y or Z. What has the petitioner presented to show, and is it convincing? There are some cases, for example, when a fitness requirement is imposed, there are some cases this court has seen where a respondent has been able to demonstrate fitness. Similarly, in a disbarment cases, there are some cases where a petitioner has been able to show that in fact they have acknowledged the seriousness of their offense, they've sought to ameliorate the effects of their misconduct, and they have demonstrated that, or they have demonstrated evidence that they will no longer engage in that misconduct again. I would ask the court, looking at the totality of evidence this petitioner has submitted, are you convinced that he has made that showing? I would suggest the record is not clear. I would suggest much of the evidence relies solely on petitioner's testimony. The lack of documentary evidence is significant and troubling. And so in our view, his clear and convincing case has not been made, particularly when you apply the Foley test, which says where the misconduct was practice related, he really has a high burden. Has he met that burden?
The way you framed it right now is as though the question is, are we convinced? And I wonder whether that's the right framework, or whether instead the issue is whether we should defer or not defer to the board's conclusion that it was convinced. Do you agree that we owe some deference here to the recommendation of the board on this question?
Your Honor, I would not use the word deference. You certainly owe some respect to the board's recommendation, but I would note it is a recommendation. The ultimate responsibility, as in all such cases, relies with the court. So I think it is appropriate to say the court. And I would point out that in Pennsylvania, you had the Pennsylvania Disciplinary Board recommending reinstatement, and the Pennsylvania Supreme Court said no. And I would urge this court to follow the lead of its colleagues and say no. Their record was very similar to the record here, and they concluded it was not sufficient. And I presume that court also gives respect and maybe even deference to the recommendation of its disciplinary board. And in this case, it said no. We think in this case, this court should also say no.
All right, thank you, Mr. Link. Unless there are any other questions from my colleagues, I'd like to hear from the petitioner, Mr. Blitzer, or counsel for petitioner, Mr. Blitzer. You're on mute, Mr. Blitzer.
May it please the court, Abraham Blitzer on behalf of MOHAMED ALAMGIR, who is the petitioner in this case. Our position is pretty simple, that It's our position that the court should find that the board and the hearing committee got it right. I'll start by addressing the issue of the Section 14 affidavit. What the board took into account, first of all, just to clear up, there was never any live testimony before the board leading up to the board's decision to apply nunc-pro-tunc treatment. Mr. ALAMGIR filed a motion with the board requesting nunc-pro-tunc treatment, and the board ruled on that motion. So there was no testimony about why Mr. ALAMGIR didn't file his petition in the proper way and address it to the proper people. The board found—
If that was relevant, he could have, in his motion, made factual representations, and if there were factual disputes, maybe a hearing would have been needed. And so when he argued to the board that his letter should be treated as sort of substantially compliant and therefore be given nunc-pro-tunc status, what did he represent about why it was he didn't follow what the rules say and what the court's disbarment order said that he should do?
He did. It really, beyond simply believing that the letter that he sent was sufficient until he learned otherwise, he really did not address that. It wasn't—
Well, the letter was 7 years after the disbarment. So there's the problem of why he didn't do in 2004 what the rules say he should do and what the order said he should do. And then there's the question of why he sent a letter in 2011 that wasn't sworn and sent it to the wrong entity. And you're saying, I guess, are you saying that there was testimony? I thought, and maybe this was at the hearing, down the road, but I thought there was testimony that to a degree touched on this, where he said, I didn't send an affidavit in 2004 on advice of counsel. Is that correct? That at the later hearing he said that, or where was that said?
That does not comport with my recollection of the record. I think the board may have said that, he thought that the letter was sufficient and didn't find out that he was wrong about that until he went to file his petition. So why he didn't do it and why he didn't realize sooner that the letter was deficient really was not explored. What the board focused on was, did the letter address the key elements and requirements of Rule 14? That he had no active clients, that he had no active cases with opposing counsel to notify, that he had returned all client property, and indicating which jurisdictions he had been admitted to and the status of those jurisdictions, and his address. I think that was what was contained in the letter, and the board considered the purpose of the Rule 14 to require that an attorney who's been disbarred or suspended does what's necessary to protect that attorney's clients, and with respect to opposing counsel, and to make it clear what other jurisdictions he had been admitted to. And the board's focus was that since Mr. ALAMGIR, in his unsworn letter, had clearly done that he had satisfied the spirit and the purpose of the rule, and that his doing this in an unsworn letter rather than in an affidavit really went to form more than the substance of what he had submitted.
The board,
Nobody is, I'm
excuse
sorry.
me. The board seemed to focus on the sworn, unsworn issue, but did the board look at or discuss the fact that the letter, not affidavit, was never submitted to the court? And if I understand the record correctly, the initial letter, the 2011 letter, is sent to the bar, not to the board.
Yes, you're correct.
Right. And so the rule expressly states you have to file this with the court and the board. And the order disbarring your client also said you have an obligation within 10 days to file this affidavit with the court and the board. Did the board consider whether the filing of that with the appropriate parties who, presumably have oversight roles was a core requirement or not?
It did not. The board's focus was on the substance,
right?
rather than.
Do you think that that the entity with whom the affidavit must be filed is a core requirement of the rule? I mean, if I fill out a Rule 14G affidavit and I send it to the mayor, have I complied with the rule?
You have not. And nobody is arguing that Mr. ALAMGIR's letter complied with the rule. The question is whether or not, having eventually corrected the defects, which as to who and where the affidavit was sent, and presenting the affidavit in proper affidavit form, whether that letter, which otherwise complied with the requirements of the rule, whether Mr. ALAMGIR should be afforded non-proton treatment.
Can I ask you, would you think that, I mean, sending an unsworn document to the wrong entity is, procedurally a pretty big whiff on what was required. And I get your point that if you're looking at it substantively, if the board later determines, in fact, he took the steps relative to his clients that were substantively intended, it almost seems as though the board's reasoning wouldn't require that letter at all. The board could have said, look, what really matters is, did the proper steps that you're outlining in your Rule 14G affidavit, timely filed if you do it properly, were taken. And so in a case where the lawyer does the things with the client that you're supposed to do, but never files any letter with anybody at any point, and just files a reinstatement petition, do you think the logic of the board's approach here would leave open the idea that the board could say, well, that's true, never filed anything with anybody, but substantively there was compliance with the requirements of Rule 14G? Because it doesn't seem that much far from that to have instead 7 years late filed an unsworn document and sent it to the wrong place.
I understand Your Honor's argument. However, this was the question is whether or not to afford the non-proton treatment. And the way the board looked at it was, yes, this was filed late. Yes, it was sent to the wrong place. Yes, it was not an affidavit form, but because there is this document on record that he did file in some way, shape, or form with the judicial system. And since he apparently had complied.
Why do you say file with the judicial system? I thought it was sent to a non-judicial entity.
It was sent to the DC Bar. DC Bar forwarded it to Bar Council. That's what was done with it.
There was no request to forward it to Bar Council. It was just sent to the K Street address of the bar before they moved to their current location.
Yes, that's correct.
I mean, I guess I just wonder, you know, to Judge McLeese's question, it seems like the big difference here is that if you send it to this letter to the wrong entity in the wrong format, you're undermining any oversight ability that the rule seems to contemplate. Do you think that the rule just doesn't have an oversight component to it?
I suppose, I don't know. I think the purpose of the rule is to assure that attorneys whose right to practice has been suspended or has been taken away completely, that those attorneys, that their clients are protected, and that that opposing counsel are notified, and that their clients' records are returned and files are returned. I haven't really thought about whether that's a regulatory or supervisory matter. I know in the normal course, if an attorney files that affidavit and files it as an affidavit, Bar Council will review the affidavit, and if there's something that doesn't meet the requirements, disciplinary counsel notes that, and the court and the parties can deal with it accordingly. And it certainly would have been better. Mr. ALAMGIR apparently did withdraw from all his cases, did return all his client files. He followed the steps you're supposed to follow. And I think that's why the board felt that even though the 2011 letter was certainly technically deficient, that because the letter complied with the substance of the rule, and because it did not appear to involve, what was their second, no unfairness to the parties, that this was an appropriate case to afford non-proton treatment.
Counsel, I want to wrap back around to a factual point that we were discussing before, because I was trying to see if I could locate in the record the reference to your client and relying on advice of counsel in connection with these letters. And I think it seems like you're right that there wasn't testimony on it. What it was that it was a declaration that your client filed in connection, I think, with the non-proton issue. And in that declaration, the reference to advice of counsel actually seems more focused on 2011, 2012 than 2004. But what it says is, on advice of counsel, I sent a letter to the board on professional responsibility in lieu of filing. And that got me confused because I thought the letter was sent to the bar. Is that an inaccuracy in your client's declaration, or are you not sure?
I know the letter was sent to the bar and it wasn't sent anywhere else. He clearly, if he was trying to comply at the time he sent the letter to the wrong person, to the wrong place. And I assume that he still may not be as conversant with the various parts of the disciplinary system. I'm sure that that was the basis of the declaration.
And yet, when we ask people to join the bar, they are obligated to read and understand our rules.
They are. And no one is arguing that that he complied with the rule, or that he had some good reason for not complying with the rule. The board focused on three things: the issue of whether the substantive purposes of the rule were achieved by the letter, whether there was dishonesty. It seemed a little bit vague to me. Certainly the misconduct involved dishonesty. The board seemed to focus more on the fact that he had entered a guilty plea in conjunction with the misconduct, and that there was no indication that he had not cooperated with the investigation of the original misconduct. And finally, fairness to the parties was the third consideration that the board had. And the board came down that in light of what it had before it, that it would not be unfair to the parties to permit the 2011 letter to be the source of non-proton treatment.
All right, thank you, Mr. Blitzer. Any further questions from Mr. Blitzer before we allow a moment or two for rebuttal?
I'm sorry.
No, go ahead. If you have additional argument, I didn't mean to short circuit.
Well, there are a couple of other issues that I'd like to touch on. First of all, is really the first issue that disciplinary counsel addresses, that the nature of the misconduct was such that Mr. ALAMGIR should not receive any consideration and shouldn't even be, that the court should not even entertain his petition, that he should be disbarred for life. We cannot minimize the gravity of his misconduct, and we totally understand that. But we would argue that in the cases since McBride, the gravity of the misconduct is used to inform whether or not a petitioner has satisfied the remaining Roundtree requirements. Here is a man who undeniably had lost his way, who had engaged in this long-standing pattern of misconduct, who in his own admission at the hearing, who did this out of greed. And since his release from prison, has sought to make up for his past wrongs by engaging in humanitarian charitable work. Bar counsel suggests that he belonged to a couple of organizations, and that clearly understates what Mr. ALAMGIR had been doing. He had been engaged in a series of charitable work in helping to raise funds. Mr. ALAMGIR had been working at a 7-Eleven for a couple of years prior to his submitting the petition. This isn't a question of his giving sums of money. His offense was an offense of greed, and his actions in donating his time and assisting the community that was embarrassed by his misconduct is an appropriate way of trying to atone for the pattern of conduct that got him disbarred.
Counsel, do you want to, I mean, I take it that you don't dispute disciplinary counsel's argument that even if your client's prior conduct isn't categorically preclusive of reinstatement, it is sufficiently serious that the court should, and the board was required to look at the other round-tree factors with heightened scrutiny. Do you agree that's true?
I do.
And the board, I think, makes really, I guess, at least two principal points about why, if we are applying heightened scrutiny, your client fell short. And I want to give you a chance to at least quickly address them. And one of them is essentially, I think it's paraphrasing their point, if your client's prior conduct was through greed, essentially getting $2.7 million or something like that, you would think it would be a very important part of your client's responsibility to show that your client had taken the necessary steps to make good on his prior misconduct, that he would make a very clear showing of, I gave back all of the $2.7 million, or I didn't, but here's why I didn't. Here's exactly what I did. Here's what happened with the 5 properties. And that your client just fell short of that. Your client has, there's like a release, which means, okay, at some point the United States decided not to further try to, go after your client. That's not necessarily, that doesn't tell you a ton about why or the like. And then disciplinary counsel is also critical of your client's testimony about what happened to the 5 properties. It seems like they're, somewhat vague and raises some other possible concerns about litigation that wasn't disclosed and the like. So what's your response to the idea that there was a heavy burden on your client to explain all of that and your client just didn't adequately do so?
We believed that with respect to the assets, in the Pennsylvania proceeding, petitioner had satisfied Pennsylvania Bar Council with regard to that, with regard to his repayment of the fund of the, not the judgment, I'm sorry, the assessment. And
I'm not quite sure. I mean, this was a proceeding in front of the DC disciplinary authorities. Unless you're saying there's some kind of a offensive collateral estoppel going on, I would think that whatever happened in Pennsylvania, obviously not ultimately favorable to your client, wouldn't really, I don't think your client could reasonably have thought, oh, well, I don't really need to provide chapter and verse here because there's an interim determination by some other disciplinary entity. That seems not that reasonable approach to carrying a burden on an issue where the burden is on your client by clear and convincing evidence.
I understand the court's position. All I can respond to that is that I don't know what evidence was available to the counsel who represented him in the Pennsylvania reinstatement. I know we had what was available to us to present, and we presented it.
I'm not quite sure I know what you mean when you say what was available to you. I assume that, at least in principle, it would have been possible. I mean, if there was litigation and there were, I would have thought your client might have a fair bit of information or could reconstruct information about what happened to properties he owned. So I'm a little unsure what obstacles you're kind of adverting to in suggesting that you presented everything that was available to you as though there were some impediments to identifying further information.
I can, to answer your question would require me to present evidence that's not in the record. I can tell
And
you.
I prefer you not do that. So I'm not asking you to tell me things that are outside the record. I guess the difficulty is, if your client was trying to show by clear and convincing evidence, look, I know I stole $2.7 million, but I have done everything I can to make that right. And if part of trying to show that was, well, what happened with the proceeds? If there were obstacles that made it hard for you to show that in the DC disciplinary process, then I would think it would be incumbent on you to try to bring that to the attention, create a record on that in the DC proceeding itself. So I don't want you to try to suggest in this court for the first time what those would be, but it's just a difficulty with your client's argument that an important part of showing that reinstatement is warranted, you would think would be, it's true I stole 2.7 or, wrongfully obtained $2.7 million. And it's true I can only show I paid back 700,000 of it. That leaves, that would leave somebody to be pretty concerned about whether your client still has the benefit of the wrongdoing and hasn't made that right. It's just, if the record doesn't really provide very strong grounds for confidence that your client did do that, you can see why it would be a matter of concern.
I can, and I do. What I can say is that for somebody who, if you believe that he still had millions of dollars worth of real property that he was holding on to, it sort of seemed inconsistent with someone who's working at a 7-Eleven to be holding millions of dollars of property. And I think that was something that the board noted. I just want to address one comment that disciplinary counsel made with respect to the Pennsylvania proceeding. The Pennsylvania's version of the Board on Professional Responsibility recommended reinstatement. The Court of Appeals of Pennsylvania denied reinstatement without comment. So we don't know what that court really found to be deficient. There's no indication that the court rejected all the findings that the disciplinary board made, whether the court found what bar counsel is having you argue, that the nature of the offense was such that he should never be reinstated. We just don't know. But the findings and conclusions that the disciplinary board made were not individually rejected by the court. It was the conclusion, and it was rejected in a conclusory way. And I think the disciplinary authority in Pennsylvania found that basically that Mr. ALAMGIR lacked the resources to further satisfy the assessment, and
I get your point that we don't really know why the ultimate disposition of the reinstatement petition in Pennsylvania was what it was, because the court's order is not explanatory. So I take that point fully. I think that's a very fair point. But to the extent you're suggesting in your comments, well, the analog of the board made some conclusions and findings that were favorable to your client, you're not suggesting that we should defer to those or rely on them or take them into account in any way, or are you? I would have thought that, that's its proceeding. It did what it did on whatever record it had in front of them. And ultimately the court wasn't persuaded. So I would think at most we would treat that as kind of a non-event. We don't know, but are you suggesting we should give some sort of deference to the factual conclusions that were reached in the interim recommendation of the analog of the board in Pennsylvania?
Well, what I'm saying is that those factual findings were there, and they were directly relevant to the concern the court has raised about my client's what happened.
My question is, are they relevant? If some other entity on some other record, or some record that we don't know, some other record made factual findings that were not rejected, that led to a recommendation that was not recommended by a court in a different jurisdiction, why is any of that at all relevant to us? I mean, I get the point.
I would say
in connection with that, and those made their way into our record, and so I get the idea that that's relevant. But are you suggesting that the findings themselves of the Pennsylvania's equivalent of the board are in some sense relevant to how we should resolve this case?
I would say that from the evidentiary perspective, it goes to weight rather than admissibility. The court has that. The court is expressing concerns over the degree that Mr. ALAMGIR was able to demonstrate what happened to his ill-gotten gains, and it's there. It's up to usually the finder of fact to decide how much weight to put on those findings. And the court has called into question whether or not and
Did
what
the
kind
hearing-
of evidence.
I'm sorry to interrupt. Did the hearing committee rely on the Pennsylvania analog?
I think I'm hesitant. I think that they may have. I really am reluctant to say whether they did or not without reviewing the hearing committee's decision.
We'll go back and look. Thank you.
All right, Mr. Blitzer, are you, did you still have additional arguments? I know we've been very generous with the time for both counsel.
I've certainly made the most points. I really feel that I really am urging the court to find that both the board got it right with its exploration of the issues about how to deal with the letter and the request for non-proton treatment with respect to the affidavit were correctly analyzed and applied by the board. And we also would ask the court to adopt the findings that the hearing committee made. The hearing committee saw the testimony of the witnesses, got an ability to judge the credibility, including the petitioner's credibility. And we would ask the court to adopt the hearing committee's findings as well. Thank you.
All right, thank you, Mr. Blitzer. Mr. Link, let me give you a couple minutes for rebuttal.
Thank you, Chief Judge. I just have one point to make. If the court agrees to grant non-proton treatment to the letter that was filed in 2011, that will be a dramatic departure from the law in this jurisdiction, and it undermines the application of a section 14G. Note, by the way, that letter was filed 7 years after it was supposed to, an affidavit was due to be filed. It was unsworn, an affidavit is filed under oath, and it was mailed to the DC bar. It wasn't mailed to the court. So it in no way complied in any way, shape, or form with the requirements set forth in this court's order. And if you grant nunc-pro-tunc treatment to it, I guarantee you we will see other petitioners in later cases relying on that ruling to avoid compliance with Rule 14G and the affidavit requirement. The importance of 14G, you get a sworn statement under oath and it's filed with the court. So the clock, if you will, is ticking as to the time for the 5 years to run. So that would be a dramatic departure, and we urge the court not to do it.
All right, thank you. We thank both counsel for your briefs and arguments, and you're free to exit our virtual courtroom at this time. All right, good morning, counsel. This is our second matter today for oral argument. In re Wendell MACKLIN and District of Columbia. Counsel, are you ready to proceed?
Yes, Your Honor.
Okay.
Good morning. May it please the court. Holly Johnson for the District of Columbia. I would like to reserve 2 minutes for rebuttal. The IDA's bridge provisions provide a different way to be detained for emergency observation and diagnosis under the Irvin Act, and that detention is thus subject to extension under Section 21526D of the Irvin Act. We know this because the bridge provisions provide for, as soon as the detainee is released from criminal jurisdiction, provide an immediate right to request a probable cause hearing before the family division pursuant to 21-525. Now, 21-525 refers to a hearing under emergency hospitalization under the previous section, Section 524. And Section...
I know a lot of questions from us as we try to unscramble in our minds, or at least from my perspective, how these two statutes interact. And I wondered if you could start from sort of just a foundational level for me on how in your view, do you reconcile the differing purposes of the two statutes? The Incompetent Defendants Act is for rehabilitating the competency of a defendant to stand trial. But the Irving Act provisions are where there is a mental illness that's been determined, where a person is likely to injure themselves or others. I guess that's my first question. And then the other question you were starting to get into was about the sequence and timing of the different hearings for probable cause under the Irving Act provision. So that's compounded, about 3 questions in one, but if you could take a stab at them, please.
I appreciate that, Your Honor. These statutes are difficult to talk about, and I have found it easier to create some shorthand and labels that I'll explain as I discuss them, which I think will help. The IDA itself mostly involves incompetent defendants, but there's a section of it which I, in my brief, have labeled the bridge provisions, and I think that's a good shorthand for them. There are 2 provisions that involve what to do when someone is incompetent to stand trial, but a civil commitment petition has been filed. Now, these bridge provisions actually were first enacted before the IDA. There's a separate statute that was enacted in 2004 called the Prevention of Premature Release Amendments Act. And that's cited in my brief. It only existed for a year, but it has its own committee report that explains what was meant to happen, like why those bridge provisions were enacted. And what we know from that committee report is that the primary goal of the council was to prevent the criminal division from releasing custody and releasing someone onto the streets when a civil commitment petition had been filed. So while there are definitely different purposes for hospitalization for restoration of competency and hospitalization due to dangerousness, there is a clear link between the two. So if you'll bear with me, I'll walk you through how I think these bridge provisions work. And again, I'm going to give you some labeling. What the council has provided are two options for a criminal division once it makes its Jackson finding. It's finding that someone is incompetent and unlikely to regain competency in the reasonable future. Those two options are: option one, the criminal division can hang on to jurisdiction and can keep the person hospitalized all the way through the end of the commitment proceedings. Option two is—
Can we just key ourselves to the statute here? So there you're
Yes.
talking about 24-531-072. Is that correct?
yes. No.
No, sorry, 24-531-072A2.
That's correct. That's
There
correct.
we go. Okay.
And then-
passed the
and then-
test, right? And so in that instance, right, the criminal court can say, and by what standard, it's not really clear, but can say, you have to stay in custody for treatment until the civil commitment decision by a judge is issued, right?
Yes, that's
So
option
to the
one.
extent that we're concerned about gaps, here's a provision that allows for no gaps. But
Correct.
in this case, the criminal court initially availed itself of this provision, but then said, actually, I'm going to release you from criminal custody.
So that's correct. And this brings
Right.
us
And so
back.
then we move on. So then take us through the statute. Where do we go next if you get
I
ready?
just before we go there, just to make sure whether this provision permits or doesn't permit gaps or how effective it is may depend, I gather, on whether it is constitutional or not, which is a matter that seems to be of some dispute. Is that right? I mean, again, if it's unconstitutional, this provision, then it may or may not leave gaps, and that may or may not be relevant to how to interpret the remaining provisions. But I just wanted, am I right that there seems to be at least some dispute about whether that provision is constitutional?
I do not believe that is a dispute that is before this court. Mr. Macklin has said he does not concede the constitutionality of option one, but he doesn't say it's unconstitutional. He doesn't say that if this court interprets the Irvin Act or interprets this in a certain way, it's unconstitutional. And I want to point out that option one is the only option available under the federal statute, under the IDRA.
Well, before we go to the federal statute, just to back up, I don't think there's any disagreement that this issue isn't before us as a court, but certainly as we interpret 21-526D and what relevance it has to a Jackson defendant, then we could back up into 24-531-07A2 to determine how gappy these two statutes are when lined up next to each other. Is that fair?
I'm not sure I understand the question.
Yeah. It's more of, should we be looking at this when we're interpreting the statutes that are before us versus going out and examining the constitutionality of 531-07A2 independently? I don't think anyone thinks the latter is teed up here. But don't you think it's fair to say what Judge McLeese just posited, which is, the breadth of 24-531-07A2, now I'm saying it really fast, could impact how we interpret 526D.
I think that's right.
I'm so sorry.
I know it's really hard to
Yes.
talk about these, and that's why I was labeling them. Option one would be
I
531.
know, but I sort of resist your labels because
That's
I
fine.
think your labels might build in some of your advocacy, which is fair. But we're here to determine whether or not we agree with your advocacy. So I'd rather sort of stick with the actual statutory provisions, as awkward as they are.
Understood. So the way I think this court should analyze the question is, what did the council intend when it enacted what I'm calling option 2, which is codified at 24-531-07 C1 and C2. So 07A has to deal with the criminal division hanging on to jurisdiction. 07B is irrelevant because it has to do with intellectual disability. 07C has to do with this catch-all provision that makes sure that that there is no gap, that nobody gets improvidently released. And that's what the council was concerned about. That's again why
Hold on, a no gap for who though?
So what the council was concerned about was that the district does not have control over which option the criminal division chooses. And the council was concerned that even when a civil commitment petition has been filed, the criminal division may release someone and that person could end up out on the streets. And in fact, if you look at page 3 of the committee report, this premature
of the 2004 legislation that isn't the legislation that's actually before us, but is the predecessor to the 2005 legislation.
Yes, it's not codified in the same place, but all of the operative language before this court is the same. So yes, if you look at page 3, the council actually says that their reasoning is that somebody was released to the streets when a civil commitment petition had been filed and he murdered someone. So that's what the council was concerned about.
In 2004. But in 2005, when they passed 24-531-07 C1, can we look at that, the language there?
Yes.
So C1 says, if the court orders the release of the person, right, they don't go the A2 route, and a petition for civil commitment has been filed pursuant to the Urban Act 21-541, right, and in a non-emergency setting in which a person is presumptively at liberty, the court shall remand the person to an inpatient treatment facility, which, as I understand, can encompass either St. Elizabeth's or a private hospital.
Can I stop you there?
Sure.
Because it says the inpatient treatment facility, I believe it has to be the treatment facility where the person was hospitalized for competency treatment.
Okay, but in an inpatient treatment facility defined under 24-531-01 includes St. Elizabeth's and any other physically secure hospital for the examination or treatment of persons with mental illness. So that seems to include private hospitals, as long as they've got a secure psych ward.
I believe it could. I don't know whether that happens
Right.
in practice, but yes.
I had no idea, but this is just how the statute is written, right? So the criminal court can remand the person to the inpatient treatment facility, potentially a private location, and the inpatient treatment facility may detain, doesn't have to, and may detain that person pending a hearing on the petition conducted pursuant to 21-542. So pending essentially a hearing in front of the commission on civil commitment, not on emergency commitment, right?
Yes.
So if you look at that plain language, right, there's nothing in there that indicates that the individuals that we're talking about are likely to injure themselves or others or must be detained until civil commitment proceedings are fully completed with a judicial order, right? So to the extent that the legislature's objective was to keep dangerous people locked up, that's sort of an awkward way of going about that.
So there's two reasons why we know that the intention was for the person to remain hospitalized. Actually, there's three, because again, I would go back to the
Well,
2000.
I'm just sticking with the plain text. Would you agree that the plain text doesn't say anything about people who are likely to harm themselves or others? So maybe you say, well, look, it's ambiguous, but we can get there. But here we are, we're trying to interpret statutes, multiple statutes, And so, one of the things that I've been wrestling with is just sort of the beginning of the analysis, right? Like plain text. Well, if we start with the text of the statute that Mr. Macklin was actually held under, which is 21-526D, the plain text of that statute does not seem to speak to him, right? And I understand the government's argument is, well, if you look at that statute with this statute, 24-531-07C, you can get there. And maybe that is true, but I'm still struggling with how one gets there with the plain text, as opposed to saying, well, look, these statutes, maybe they're ambiguous, but if you read these statutory schemes in conjunction, this is the logical reading. So that's a long explanation, but I guess my question is, are you making a plain text argument, or are you going sort of it's ambiguous, but you should interpret it our way because our way makes the most sense argument?
We are making a plain text argument, but it includes subsection 2. And I don't think you can take a statute, take subsection 1 and not look at subsection 2. It's still part of the same statute.
Okay, let's move on to subsection 2.
If I can just slow us down to make sure. So if we're going more slowly, so we're to the point of C1 that says the court shall remand the person to the inpatient treatment facility, and the inpatient treatment facility may detain the person. I mean, it is a funny word if you're trying to preclude a gap to say, well, the inpatient treatment facility may or may not, without giving the inpatient treatment facility any real guidance statutory guidance about how to make that seeming optional determination. But it says may detain pending hearing on the petition conducted pursuant to 542. And if you then go to 542, so that tells you, it says send them to the facility, and then it is a provision for a certain period of time about at least authorizing detention, not requiring it, but authorizing detention up to a point. So let's just, for a minute, just walk through someone who's going that route. Not our situation, because I think by the time of this order, the person already had the hearing. So it's not quite our situation, but imagine what probably is a more ordinary course of events where the hearing hasn't happened. So the person, the inpatient treatment facility decides, yes, we will detain the person. Let's imagine. And leave aside C2, which could come into play, but imagine it doesn't. And so then eventually the commission holds a hearing under 542. Now, then the question is, what happens to the person after the hearing, just following through the path created by C1 and its interaction with 542? Because it doesn't really send us to the emergency provisions. It sends us to 542. And so if the commission says not dangerous, not likely, not dangerous to self or others, and recommends against commitment, involuntary commitment, then what do you think happens under this statutory scheme to the defendant?
Well, I guess the reason why I'm struggling with this question is I don't think you can read C1 without also looking at C2.
I understand that C2 could come into play, but imagine it just doesn't.
I think it does. I apologize. I didn't mean to interrupt.
Imagine that the person doesn't request a probable cause hearing.
I think
So
that even. I
what
apologize.
happens to such a defendant? That's all right. Could you just tell me what you think happens to such a person?
So I think that the standard that is incorporated from C2 applies even if the person never seeks a probable cause hearing. So, and this is not true under the Superior Court's interpretation, but under the district's.
To be clear, I guess now this is not anything that you find in the word. If you're just walking through C1, it doesn't really tell you what to do, I guess, with a person in the hypothetical I'm asking you. So again, the person is, in a criminal case being held, unlikely to regain competence, and the criminal court says, I'm not going to keep him detained or her detained in the criminal matter. So now we're in C1, and there hasn't been a hearing yet. There has been a petition filed, a non-emergency petition has been filed, and the court says, I'm remanding you back to the facility where you've been held up to now, and the facility says, we're going to hold you. And then the commission holds a hearing, and they're just, in this particular case, nobody ever invokes C2, let's imagine. I understand you think that it will tell you some things, but what the statute says directly is, well, commission needs to make a determination under 542 about whether commitment is warranted or not. And if the commission says no, commitment is not warranted, my question is, what happens then in that case to the detention of the former criminal defendant?
So if, under the district's interpretation, the release order under C1 itself routes that person into the emergency hospitalization provisions of the Irvin Act.
How
What-
so?
what-
Because it actually routes you directly to the civil commitment provisions. It routes you to 21-542, right? That's part of the civil commitment provisions.
Yes.
And
but-
so it seems to say this person, look, this person is a different category of potential civil committee, right? They have been accused of a crime. They've never been convicted of a crime. They've never been found guilty of a crime. There's no determination of dangerousness. There's no emergency petition that's ever been filed. But we will go so far as to allow the inpatient treatment facility to hold this person pending the civil commitment decision by the commission, right? Just by the commission. And at that point, you're funneled not into the Emergency Act, but into the civil commitment statute, the regular Irvin Act.
You don't
And
have
why
to be.
isn't that what the plain language says? I get that you say, actually, this, you're reading it all wrong and we interpret it differently. But the plain language seems to take you not to the Emergency Act, but to the regular civil commitment provisions, which again allow you to remain at liberty unless and until a judge says you should be committed.
I'm afraid I probably don't have a better answer. I do think that the plain language comes into play under subsection 2. I think that subsection 2 informs subsection 1. If the court does not want to.
So let's go to subsection 2. And I guess part of the reason I struggle with that interpretation is because it starts out just with this within 7 days provision. So subsection 2, sort of under the plain language, seems to expire pretty quickly, right? It's like, you can go this route. It's on the petitioner or the putative committee, and then it's done. So I think that's sort of my, and then to Judge McLeese's point of what if you never request it? How does that person who has been remanded, a Jackson defendant who's been remanded but never been determined to be dangerous to himself or others, suddenly become an emergency detainee? That's where I get lost.
So I have two responses to this. And the first is that the routing someone into the Irvin Act provides more protection than the probable cause act, than the probable cause hearing itself. Somebody who is emergency hospitalized has the benefit of section 527, which requires the hospital, and it's 527B, which requires the hospital to conduct an ongoing analysis of whether the person satisfies the emergency hospitalization standard. If
Actually,
where
I
was
mean,
that
before,
here? Yes, that's where I'm struggling. Like my colleagues, with the automatic rerouting to the Irvin Act emergency hospitalization provisions, I don't see where there was a determination, or when there was a determination made that there was a mental illness, number one, which I thought needed to be done under the Irvin Act, but more importantly, whether there's imminent danger to self or others. And it seems like the process was inverted or upside down. The show cause hearing happened before the criminal case was ended. So where was that done here? And isn't that the point of the hospitalization under the Irvin Act?
Well, I think
determination of a mental illness. There are ongoing assessments and evaluations, but more importantly, that there was, under the emergency hospitalization provision, imminent danger of self to self or others.
So that standard for imminent dangerousness applies from the beginning of emergency hospitalization under Section 521 all the way through.
Right, but when was it made? When was the year where they sort of automatically almost transferred over? When was that determination made? Doesn't it have to be made normally before someone is hospitalized?
It has to be made when you pull someone off the street in order to create a lawful detention. We think the best reading is that the council just didn't think it was necessary for that initial ex parte decision because the person was already in lawful custody. And if they seek—
But why are they? I mean, they've been charged with a crime. They are in custody. The fact that they've been charged with a crime and are in custody do not immediately translate into there is a likelihood that they will imminently harm themselves or others. It just doesn't. I mean, they might be in custody because they just failed to appear, 10 different times.
Right.
And then got Jacksoned.
Okay, so
and I think what is troubling me is that the government's argument seems to be skipping over. I think this is what the chief is getting at too. It's skipping over what you just called the ex parte determination. That's a determination by a judge, right? A judge looks at a petition that is squarely directed at this question of whether or not this person is imminently dangerous to themselves or others, and says, yes, I think that there is probable cause to believe that this is true, right? So that never happens in the remand situation.
that's correct. And I want to explain why I think that's acceptable, because I do think that was a deliberate act on the part of the council. And so I want to start with the notion that this is, again, a question of the council's intent. Obviously, the council thought—
I know we keep interjecting these things to add on to your answer, but if you could fold into your response to Judge Easterly, perhaps further elaboration on my initial question to you about the differing bases for the two statutes. So when you say that the defendant here was already in custody, so there was no need to do this ex parte hearing, it goes to my question about the different reasons that people would be in custody under the IDA statute versus the Irving Act. And I think it dovetails specifically onto part of your response to Judge Easterly's question as well.
Yes, I'll try to fold that into my answer. The council was not concerned about a detention of a couple of days when somebody was already in lawful custody. Remember, the criminal division can always go with option one, and even after a Jackson finding, hang on to jurisdiction. The most important thing about this process is the probable cause hearing, and that's why I keep harping on that. The probable cause hearing is available within 24 hours, meaning that somebody could get their probable cause hearing before the ex parte determination would ever even come into play if someone had to do the FD12 process or start with emergency hospitalization after the criminal division releases custody. Remember, the ex parte hearing comes within 24 hours of the emergency hospitalization petition, and the hospital can hold a person under, even if they take them off the street, for 48 hours before then without any judicial review. Obviously, a probable cause hearing is a lot more process than the ex parte ruling. And we know for certain that the probable cause hearing is under the standard for emergency hospitalization. We know that from the committee report from this 2004 statute, which says the hearing is to determine whether the person raises an imminent risk of harm to themselves or others. In response to your question about whether the person is mentally ill, we know they're mentally ill because they were found incompetent to stand trial due to mental illness. So the standard for emergency hospitalization kicks in the moment the criminal division releases custody. And indeed, the liberty interests of the individual are better served by holding that this routes them directly into emergency hospitalization than by holding that somehow the hospital can detain them for several months under the standardless provision. I'd like to explain those reasons to you. I think they're important. Under Section 526C, the one right before 526D about continued hospitalization, that creates a right to a speedy commission hearing. So if you're brought in off the street under emergency hospitalization, after that 7-day emergency hospitalization order expires, if a commitment petition is filed, that detention can be extended by 21 days. And a continuance can be granted, but it's generally not more than 2 weeks. If this court holds, if it affirms the Superior Court's interpretation and holds that your detention when you get remanded to the hospital from the criminal division is not under the Irvin Act, then there is no speedy hearing under the commission. You also don't get to take advantage of the hospital's continuing obligation to make sure you satisfy the standard for emergency hospitalization. And if you'll bear with me, I'm going to explain one more thing that I think would satisfy some of these concerns. We believe the best reading is not just that the probable cause hearing then brings somebody into emergency hospitalization at the probable cause hearing stage, but that in fact, because the probable cause hearing is on emergency hospitalization under Section 524. I mean, that's what Section 525 says. It says the court shall grant a hearing to a person whose continued hospitalization is ordered under 524. If this court holds that the release under C1 is the equivalent of an emergency hospitalization order under 524, then the hospital has to assess and make a certification of the person's dangerousness within 48 hours under Section 527. So I know there's a lot of different statutes.
You've lost me. Can we go back?
Yes.
To your first cautionary note, which is something about, well, wait a second, you wouldn't get your speedy hearing under the emergency provisions. So I just didn't quite follow that. So
Sure.
Under 24, you've been Jacksoned, you've been released from criminal custody, you've been remanded to the inpatient treatment facility, and C1 says, look, this facility may hold you until the commission has its hearing on civil commitment. And seemingly, except for the purposes of this discussion, that it indicates that at that point, absent some other authority to detain the individual, say, for example, the filing of the emergency petition under 521, the person has to be released. But C2 says, hey, and also, if you get remanded in this way, you can get this probable cause hearing and get released. So it seems like the Jackson's defendant can possibly get released under a hearing under 21-525, where the court has to make a probable cause finding of that they're imminently dangerous, or they stay under C1 and they're held until the commission issues has the hearing on civil commitment, in which case they're released unless and until an emergency petition is filed. What's wrong with that reading of the statute, which seems to be sort of just reading the plain text as it's read instead of looking to legislative history from a temporary statute?
So again, I want to point out, I don't think this temporary statute, it wasn't a temporary statute, it was permanent legislation that was incorporated into the IDA. And if you read the IDA committee report, it makes clear that the whole reason the IDA was put together was because when they were doing this prevention
Does the committee report for the IDA say we incorporate in whole the committee report from the temporary legislation?
No, what it says is that when we created this previous statute, permanent legislation, we discovered lots of other problems with our statute with regard to incompetent defendants. It's entirely out of date. But if you look at the operative language, it's exactly the same. And that's generally the way
Okay.
we interpret statutes.
But can we
that was
go
not
back to, can we go
Yes.
back to my question of what's wrong with, right? I mean, I'm still in my kind of, I don't know where we are with reading plain text versus, you know, the government is taking us to legislative history, which we generally don't do when we're just saying the plain text is clear, right? You know, we don't ignore it necessarily, but we don't give it the significance that it sounds like the government wants us to give it, unless we've already determined that the statutory scheme is ambiguous. But the government is saying, if I understand correctly, this is not ambiguous. This is a plain text reading of the statute. And I just gave you my plain text reading of the statute. And I'm wondering why my plain text statute is so absurd.
So we don't believe it's the better reading of the statute. Of course, our arguments with regard to the legislative history are in the alternative. We think the plain language is clear from subsection 2, but if this court doesn't agree, we're asking the court to look into what the council intended with this. And the council's main concern was preventing premature release by requiring the hospital, the district, and the family division to go through the FD12 the ex parte hearing process. That statutory scheme would introduce a great risk of improvident release. Now, the district does the best it can, the family division does the best it can, but I think this court is aware that there are probably a handful of cases every year where an FD12 is filed on the person and some time-related problem, something that goes wrong in the first 3 days, causes that person to have to be released under those first 3 steps of emergency hospitalization.
I apologize when you say FD12, you're referring to.
So sorry. I
No
am referring.
worries.
It's okay. So it becomes shorthand. Okay. So under section 521, that is the first provision of emergency hospitalization. And that provision
Yes.
authorizes a person to take someone into custody.
Right.
The document they execute when they take someone into custody is an FD12 form.
Thank you.
So that's what I
Got
mean
it.
by that. So with starting at that process, and I've cited a couple of instances, at least one in my brief from the last year, but I would say that there are a handful every year where people who need to be hospitalized, either because they pose a danger to themselves or the danger to the community, get released simply because the time deadlines weren't satisfied. And obviously, the liberty interests of someone who is not lawfully detained take precedence. So of course they need to be released. But the council didn't want to introduce new technicalities where the person is already in lawful custody and can get their probable cause hearing before they would even get to the ex parte ruling. So
back around, because I asked a question and I think we got bogged down in it. And I really try to understand what your position is about something. So if you would, I'm going to ask the question again, and I hope you'll tell me what your answer is about, like, directly, and then explain why. But just I want to know what happens in the following case. And this is back to something I asked early on. And so you imagine a case where, unlike ours, all the way to the point where the trial court remands the person back to the facility, is no longer exercising criminal authority over the person, but the commission's hearing has not been held yet. So we're under C1. And imagine, probably in not a very plausible hypothetical, but imagine that there is no request ever made under C2. So it's just going along under C1, and the commission holds its hearing. And the person is being held pursuant to the authorization in C1. The person is held in that facility up to the point of the commission's determination. And imagine the commission holds its hearing. Holds its hearing, and let's say it rules right away. Leave aside hypotheticals where there's a gap between the hearing and the ruling. And imagine right at the end of the hearing, the commission says, we see no basis for civil commitment. That's the commission's recommendation or conclusion. What is the detention status of that person when the commission issues that order? Don't tell me why. Tell me what's the status of the person.
Absolutely. Under any scenario, under option 1, under C1, under emergency hospitalization, that is the end of the commitment proceedings. If the commission doesn't recommend commitment, that is the end of, there is no trial. That's just the end and the person gets released.
But why?
Because, okay, so I'm not going to talk about option one unless this court asks me to, because I don't think that's the question here. But under emergency hospitalization, let's say the person
I'm not under emergency hospitalization. This is
under C1. Sorry.
Right, I'm under C1.
Under C1, the hospital's detention authority expires when at the conclusion of the commission hearing.
Well, I thought that's not your general position. So again, I understand that there could, C2 could come in if someone holds a hearing, but imagine no one ever requests a hearing. And so then, the commission holds its hearing. And I was trying to assume the commission ruled right away to avoid some complications. But is your view that if there never has been a C2 request, that such authority as is provided by C1 to detain someone is gone, and there's no other provision that is providing authority? I thought for detention thereafter, I thought you thought that the other provisions kind of kick in because you're kind of implicitly dumped into the emergency system partway through and treated as though you're somebody who, there's detention is kind of implicitly authorized, and you kind of jump into the emergency process partway down the line. But I'm just trying to figure out what happens in a setting where the commission, in a non-emergency setting, and there's never been a C2 hearing because nobody asked for it, the commission says, look, our conclusion after the hearing is this person, that there should not be a civil commitment under the non-emergency civil commitment procedures. What's the detention status of that person?
The person gets released. And I think I can answer your confusion if you'll bear with me, because it starts with the Irvin Act, not with, well, it doesn't start with the Irvin Act, but it hinges on the Irvin Act. So detention authority under C1, regardless of whether this court adopts the Superior Court's interpretation or the district's interpretation of what that authority means and what law, what standard governs that detention authority under C1 expires at the commission hearing. The commission does rule on the spot in answer to that question. So sometimes they'll issue a written recommendation later, but they do rule at the hearing as to what their recommendation will be. So that detention authority expires. The question is whether the authority under the Irvin Act to extend emergency hospitalization, if the commission recommends inpatient or outpatient commitment, whether that authority applies to someone who has been hospitalized under C1. And
But that's only if you get to the Emergency Act, the Emergency Hospitalization Act. And I guess I thought I saw something in your brief that said, well, after you have, yes, C1 takes you to the commission hearing. And so under C1, the Jackson's defendant has a right to be held until the end of the commission hearing. And I thought your brief then cited the Irvin Act 21-544 for the proposition that if the commission says this person, we conclude, is not a danger, an imminent danger, or not a danger to themselves or others, because the commission hearing doesn't have anything to do with imminent danger. It's just at some point in the future, we think, unless they're detained or committed, that they will be a danger to themselves or others. I thought you cited us to 21-544. Am I wrong about that in recollecting that?
I don't think I cited that for anything that was relevant for if the commission finds that commitment is warranted. If the commission,
no, sorry, if I misspoke, I thought the brief cited 21-544 for the proposition that if the commission says commitment is not warranted in our view, we're not recommending commitment, then the person has to be released pursuant to 21-544.
if they are hospitalized under C2, that is correct. If the criminal division retains jurisdiction.
Under C, this is under, sorry.
Under IDA, yeah, I know.
Under C1, right?
Oh, correct. I'm sorry. Yes, under C1. I mean,
Right.
So if the commission finds commitment not warranted, that ends all of the proceeding. It ends emergency hospitalization. It ends.
Right. And my simple question was, I thought that the government cited 21-544 to support the proposition that Jackson defendant would have to be released.
Under C1, yes, that Jackson
Right.
defendant,
And,
yes.
and that leads me to think that C1 is really funneling Jackson's defendants into the Urban Act.
So okay, so there's
The-
subchapter
sorry,
3. I hate to,
the non-emergency part of the Urban Act.
I hate to introduce new shorthand terms, but these are actually used in the statute and I think they're helpful. Subchapter 3 of the Urban Act is the emergency hospitalization subchapter. Subchapter 4 is the civil commitment subchapter. So emergency hospitalization, if it goes beyond the 7 days, always is going to include civil commitment proceedings under subchapter 4. That's the only way you can extend it beyond the 7 days. The
Can I ask,
question,
I want to make sure, you said that if the commission in a civil commitment proceeding, non-emergency, if the commission says, we don't recommend civil commitment, we don't think the showing for civil commitment has been made. I thought you said that ended the proceeding. It's very clear from the provisions that it ends the detention. That says you have to have immediate release. But it was less clear to me that it ended the proceeding, and it seemed as though it was possible that if the government thought the commission was wrong, that the government could challenge that ruling by saying, no, let's go to the court hearing and let's find out, actually, judge, civil commitment is warranted, and that the judge could then order civil commitment. So I may have misunderstood you, or I may have misunderstood the statutory scheme, or both, but
so you may be right that actually we never challenge it. So, and we don't handle the private commitment recommendations. So it did not occur to me. I suppose there could be, the person definitely has to be released. Maybe that doesn't actually end the proceedings completely. So if I'm sorry if I took so long to answer that question, I think that I was just misunderstanding. Yes. The person that ends emergency hospitalization, like under any interpretation, emergency hospitalization ends if the commission recommends release.
So if imagine the same question I asked before, but a twist, which is imagine instead that the commission at the hearing says, we think that civil commitment is warranted under the civil commitment standard, which is similar, but not exactly the same as the emergency hospitalization standard, because the emergency hospitalization standard requires imminence, I think explicitly, in a way that I'm not sure the civil commitment standard does. So imagine that the commission issues an order in a case where, where a defendant who has been sent over into this process as a result of, or at the back end of the criminal proceeding where there was a determination of incompetence and unlikelihood of regaining competence. Imagine that the commission says, we think that commitment is warranted. That's our recommendation. But says, by the way, we don't think this person is in imminent danger. Now, I don't know why they would pop off on that if they weren't necessarily required to. But what is in your view, what happens to such a person? Such a person, it seems there's at least the commission thought that there isn't a basis for emergency hospitalization. There may be a basis for civil commitment. Is it your view that that person is detained under the kind of the way you piece together C1 and the implications of C2 and the IDA and the emergency hospitalization provisions and the civil commitment provisions, or is that person not subject to detention?
Under our interpretation of the IDA and under just the straight up emergency hospitalization provisions, that person would still be subject to detention. Now, they would be subject to an ongoing obligation on the part of the hospital to certify.
Again, for a defendant, for a respondent in a civil commitment proceeding, if there hasn't been an emergency petition, emergency hospitalization process, if the commission ends up saying, yes, we think at the end of the day, this person should be committed, if that's the recommendation of the commission, that person is not inpatient from then until the judicial trial, if I understand things. Is that your understanding also?
Are you referring to somebody who has not been subject to emergency hospitalization?
Yeah.
That's correct. That's
right.
correct.
But you're saying that someone who gets sent here into this process from the Jackson versus Indiana competence IDA route would be different, because the commission even though, again, the statutory scheme expressly says you can be detained up to the hearing, that person will be detained after the hearing, even though the commission has said, well, we recommend ultimate civil commitment, but we're not making any finding relating to imminence because we don't really think there is that. That person would be, in your view, detained, even though there's been no emergency hospitalization process and there's no finding of imminence of danger to self or others, because the person got sent through the route of the IDA, and because I think, I assume, because you think that person had a remedy, which would have been to try to get emergency hospitalization type findings by invoking the protections created in C2. So I get that, but I just want to make sure I understand your view. That person, in your view, the hypothetical person I was describing, would be detained, even though a similarly situated person, as again a respondent in a mental health civil commitment proceeding, would not be detained.
That's correct. I think it's clear that the council intended to jump in at emergency hospitalization at this fourth step. And you can actually see this from the legislative history, which I think is quite persuasive. The one real change between the 2004 statute and when they incorporated that operative language into the IDA is that originally, if under sort of the last catch-all 48-hour clause, if the individual, if the district or the hospital had not filed a petition for civil commitment in a timely manner, then the court could give them an extra 48 hours. And under the first version of this statute, it specifically said to initiate proceedings under subchapter 3, which would be section 521, an FD12. But then when they incorporated that language into the IDA, they changed that to say that that would be for commitment proceedings. The council knew how to say that you had to start at section 521, and instead they deliberately routed this in at the probable cause hearing stage. So I do think it's important to question why the council, if it was so concerned about the emergency hospitalization standard, if it was so concerned about the imminent dangerousness standard applying, why it would have authorized detention all the way through the commission hearing that under the Superior Court's interpretation would be completely standardless without the Irvin Act's protections. So the protections that are provided before the hearing are just as important as those after the hearing. So the council itself, we know from the legislative history, the council's primary concern was preventing inadvertent release, which is simply a huge risk. But to the extent the court is concerned about construing something grudgingly because there are liberty interests involved, those liberty interests are better protected if the person is immediately routed into a statute that is designed to preserve individual liberty interests. I will note,
like the emergency, subchapter 3. I mean, I guess I'm just really struggling with it. How much can we rely on legislative history to look at these two statutes, 21-526D and I can't keep these numbers in my head, 24-53107C, and interpret our way to the government's understanding of them. If they don't mesh, then it seems like this should be a legislative act to take another look at them and say, this isn't operating the way that we want it to operate. But as it stands right now, it seems like there are a number of protections to address what you say the council was concerned about, which is release of people who are actually dangerous, right, to themselves or others imminently. And one of those protections is filing an emergency petition under 21-522 or something.
521, it's okay.
Thank you.
So I think what I want to do is discuss the concerns that this court even actually could resolve if it's inclined, some of the concerns that could be resolved if this court is inclined to adopt the Superior Court's interpretation. we think the plain language, actually, I'm going to start, sorry, I'm going to go back to that. That's important. But I want to start by answering your question with regard to the plain text, because we do think there's a way, it's not a perfect fit, but a way that the plain text, even leaving outside any committee report, helps routes this into emergency hospitalization. And this is what I started with, but we didn't really have the foundation for it. So you start with 531.07C, that's the bridge provision that says, and C2 in particular, that a person so detained, meaning a person who is detained under C1, may request a probable cause hearing on the person's continued detention, the first key provision, before the family court, right? Not before the criminal division. The criminal division is releasing jurisdiction immediately over the custody, not over the criminal cases themselves, but over the custodial relationship. Continued detention before the family court, and that hearing is pursuant to Section 21.525. Now, Section 21.525 is one of the steps for emergency hospitalization, and Section 21.525 itself doesn't have a standard. All it says is that the hearing is with regard to an order for continued hospitalization under Section 524. 524 has a substantive standard, and that is the standard for emergency hospitalization. So we believe this court, there's two ways this court could rule. This court could rule that this entitlement to a probable cause hearing routes the person to emergency hospitalization under Section 525. Or it could rule that it routes to emergency hospitalization under Section 524. But either way, at that point, that person's hospitalization is for emergency observation and diagnosis. And that's the key language of the kind of hospitalization that is extendable after the commission hearing. So that's the plain language argument.
What do we make of the probable cause hearing? And maybe I'm misunderstanding the procedural history here. There was a probable cause hearing held before the Mental Health Commission before the criminal division released the appellant here. What was the purpose of that probable cause hearing?
So that wasn't a probable cause hearing. That was the commission hearing. This case is very strange. Mr. Macklin requested 6 extensions, 6 continuances of his commission hearing. So he was held a long time before he got the commission hearing. After the commission recommended inpatient treatment, several months later, his attorneys sought release from the criminal division. Before that, the criminal division had gone with 07A as opposed to 07C. So in this case, by the time he was released, he had already passed the deadline for C1. I mean, this case came up to this court under strange circumstances, and it's a good thing that the merits of this case are not before this court, because I think they would confuse the pure statutory question that we desperately need answered. Everyone desperately needs this question answered. So he didn't seek a probable cause hearing until the day before he was released. And he didn't get a probable cause hearing because instead he got a motions hearing and the judge released him from the bench. So this case is...
My question is also about the probable cause language. I take your general position, which is the best way of reconciling these statutes is that these folks who get kind of sent over from the criminal process are kind of, by the best way of reading the statutes, treated as though they've already gone through the first few steps of emergency hospitalization, and you kind of pick up in media res, and then you take them the rest of the way, and that's a much more sensible way, and you avoid a bunch of duplicative or problematic antecedent steps that aren't necessary and that don't fit well in the statutory scheme. I take that to be your main submission, if I've got the gist of it down, and I think it's an aspect of that's adequately protective of the interests of folks who are being sent from the criminal process over into the system. And I just want to make sure I understand the hearing that is authorized by C2 for such folks is a probable cause hearing. So what they'll get from a court quickly, very quickly, more quickly than you might get a similar thing from a court on the emergency hospitalization side if you start at the front end, is a determination about probable cause, you say, under the emergency hospitalization standards. So imminent danger of likelihood of injury to self or others, and I assume least restrictive alternative would be a piece of that. But I guess I'm wondering whether having that made under a probable cause standard is less protective than what procedural rights folks would have if the issue were teed up through the process of emergency hospitalization. Is the judicial determination that you would ultimately get, maybe not as quickly, but ultimately get on the, if you run through the emergency hospitalization process, is that only a probable cause determination, or is that actually like a preponderance of the evidence, or maybe some more favorable standard? I'm not sure. So I was wondering what the implications are of the fact that the words here are probable cause hearing.
So it's interesting because the IDA calls it a probable cause hearing, but the Irvin Act does not. But it is a probable cause hearing. Section 525 under the Irvin Act is a probable cause hearing. So the steps that are skipped are, if we were not to start with.
Well, why do you say that? And I just make sure, why do you say that? That 525 itself doesn't say that.
Correct.
It doesn't tell you anything.
So, and I walked the court through this in my brief, and I don't know that I have the case name on hand, but so Section 525 references Section 524, which is an order for emergency hospitalization, observation and diagnosis, also contains no standard. That one, I believe, references 523, which references 522, and ultimately you get back to the emergency hospitalization standard. I believe it's the Reed case cited in my brief where this court says that is a probable cause hearing on the question of emergency hospitalization
The
standard.
525 hearing is, or the, so it's
Yes.
only a probable cause determination, and that's, I'll find that in this case, Reed.
Yes, yes, you
Got
will.
it.
You will
Thank you.
also find that in the legislative history, the standard is in the legislative history of the 2004 version of these bridge provisions. They also recite that standard.
And again, just to be clear, there's a substantive standard about imminence and likelihood of injury to self or others, but you're saying the procedural standard of by what, what level of confidence the judicial officer has to be persuaded, that's also in the legislative history, that it's a probable cause determination that you get from a judge under 525.
I don't know if that's in the legislative history. I don't know if the legislative history of the Irvin Act refers to it as a probable cause hearing, but I do know that under the Irvin Act, 525 is a probable cause hearing, and that will be abundantly clear from this court's case law. Anything under 525 will make it clear that that's a probable cause hearing. So I would like to address, just out of an abundance of concern, if this court affirms a superior
I'm
court.
sorry, could you, but I think Judge McLeese had a question about what happens at the end of, because after the emergency determination under 525, then what comes next?
Oh, I'm sorry. So, okay.
Wasn't that the
So-
question?
I mean, that's an implication of my question for sure.
All right. I'm happy to walk you through this because these provisions internest and they refer back to each other. They're very confusing. So the Section 525 probable cause hearing is a hearing on the emergency hospitalization standard. And if there is no probable cause, the person is released. And if there is probable cause, then you finish out the 7 days of emergency hospitalization. If a commitment petition is filed during those 7 days for someone who came in off the street, if a commitment petition is filed, then that detention is extendable. The detention for emergency observation and diagnosis is extendable. And this is under 526C, which I referenced earlier. It becomes extendable, but only by 21 days for the commission hearing. And that can be extended for good cause, but generally by only about 2 weeks. So there is a right to a speedy commission hearing built in for people who fall under the subchapter 3 of the Irvin Act. Now, if you're not emergency hospitalized, you do not get that right to a speedy commission hearing. So under the Superior Court's interpretation, the hospitalization could last much longer before the commission hearing because subchapter 4 says only that the commission must hold the hearing promptly. So there is
at least as far as a statutory matter. I mean,
Correct.
There might be other limitations.
Sure,
And,
of course.
And just to clarify, as I'm looking through these procedures and walking through them again, it's at 526D where the commission makes some determinations that include like least restrictive alternative and the like. On your theory, the hearing that a defendant coming from the criminal process over gets pursuant to 525, which is a probable cause hearing. Does that probable cause hearing require findings of imminence and also of least restrictive alternative, or is it only likelihood of likelihood of danger to self or others?
So imminence and least restrictive alternative are folded together into one test, and the answer is yes. So the test is whether the person is likely to injure himself or others if not immediately hospitalized. So immediately creates the imminence, hospitalized says this obviously has to be the least restrictive alternative. Yes, those come into play at the probable cause hearing. Then under 5, if a commitment petition is filed, and they aren't always, sometimes the person gets stabilized, then Section 526C allows the detention for emergency observation and diagnosis to be extended until the commission hearing. Subsection D says that that same detention, the detention for emergency hospitalization and diagnosis, then may be continued depending on what the commission finds. And this is where we get into the—
And if the commission finds what was found here, and this is, you're relying on D1, which says that authorizes continued detention until the end of the judicial trial.
Yes. Now the hospital is still bound under Section 527B to only hospitalize the person if they continue to satisfy the standard for emergency hospitalization. But the court's involvement in that question does not come into play after that. And then the trial usually takes place about 2 months later. So the commission hearing, if you try to view it as different chunks of detention, the commission hearing appears about halfway. And I think the district's biggest concern, aside from the concern of improvident release, with regard to the Superior Court's interpretation is that while it might provide more liberty interest protection on the back half of that detention, it strips the liberty interest protection from the first half of that detention. So we think that what the council intended was to prevent improvident release and shuttle that person immediately into the emergency hospitalization subchapter midstream. And so the statutory question is, under Section 526, what does it mean to be hospitalized for emergency observation and diagnosis? Because that's what's extendable. And the district's plain text argument is that once you have been released from criminal jurisdiction, from your criminal custody, the court retains its own criminal jurisdiction. Once you become released from that, you are emergency hospitalized for emergency observation and diagnosis, and thus subject to the provisions of the Irvin Act. Oh, and I know I'm over time, but I do want to talk about these ambiguities this court could resolve in this decision, because if this court rules in favor of the Superior Court, if these ambiguities are not resolved, there will be more improvident releases before we can bring this back up to the court again. The first is the court would need, it would be really helpful if the court could resolve when admission would be. This is if we have to start at step 1 of emergency hospitalization.
I'm glad you mentioned that, because I was puzzled by your concern under 21-523, because it talks about this 48 hours limitation that you're supposed to file the emergency petition within 48 hours of admission, right? But it actually says, right, 21, hold on just a moment. It says a person admitted to the hospital under 21-522 has to be, the petition has to be filed within 48 hours. And so it just seems like a Jackson's defendant wouldn't be a person admitted to a hospital under 21-522.
That's exactly what we would want the court to decide. And I'll explain to you why we're concerned about this, because somebody can be admitted to the hospital before the FD-12 is executed. We have had a few situations come up in recent years where someone was admitted to a hospital for medical reasons. They are admitted to the hospital, and then the psychiatric reasons start requiring restraint or chemical restraint. And the Superior Court has held, well, once you restrain them and they're already in the hospital, then they're admitted under Section 522. So
I don't know that we would even have to get into that scenario. It just seems like a defendant who's been remanded, a Jackson's defendant who's been remanded would not be a person admitted to a hospital under 21-522. Right? I think it would be as simple as that. And then the government just has to file the petition within a time such that if this person is about to be released, and it seems like the government has lots of time with the Jackson defendant to kind of see where the road is going, to file the emergency petition if need be.
So that would resolve the first ambiguity, and that if this court affirms, we would appreciate that sort of confirmation. I think that would go a long ways towards helping. The next question is, when would the FD-12 be ripe? And this came up, if the court looks back to the Peterson decision involving a conversion between voluntary inpatient hospitalization and involuntary inpatient hospitalization, the argument there made by Peterson was that because he had been admitted to the hospital much earlier, that he had to be released from the hospital. No, I'm sorry, let me back up. The argument in Peterson, I was confusing the two. The argument in Peterson was that the person could not pose an imminent danger when there was no risk that he was going to be immediately released. And this court's finding in Peterson was, hey, the person had already signed himself out for release, or maybe was about to sign himself out for release. And that creates enough imminence if he's no longer amenable to treatment. So it raises a question as to whether the district would have to wait for the commission to find that inpatient treatment was recommended before the district, to create that imminence, before the district could submit an FD-12. It would be helpful if this court could clarify that the imminent standard doesn't require imminent release, because the argument we will be contending is there's no way the person will be an imminent danger if they have to be locked up all the way until their commission hearing. And what we don't want is the situation that this court rejected in Peterson, where we are scrambling to do an FD-12 when the court has already, or the commission has already ordered the person to be released. That's dangerous, and it leads to improvident release. The third ambiguity, and this is another important one for us with regard to the burden, is how many probable cause hearings is this person going to be entitled to? You can imagine an example in which under C1, the person is released from criminal custody. The person immediately requests a probable cause hearing. They get that probable cause hearing within 24 hours. And sometime within that time, the district starts the FD-12 process. Well, then the person can claim, well, now I'm entitled to a probable cause hearing on the FD-12. And are they going to get a second probable cause hearing? And if so, did they get one if there were problems with the timeliness? So again, it would be helpful if this court is going to affirm to confirm that the person is only entitled to one probable cause hearing, and that we don't have to have a doctor go sit in the court's waiting room for half a day twice. We need our doctors to be treating patients. So those, again, we think that all of this is resolved if the court just treats the person as shuttled in as emergency hospitalized. And we think that the plain language of the IDA, we think it requires it, but if the court disagrees, it's at least susceptible to such an interpretation, and that would resolve these problems.
Does it matter if we adopt your recommendation of deeming the person to be shuttled in to the emergency hospitalization provision, that there are two different burdens of proof under the IDA versus the Irving Act, where under the IDA, really the burden is on the detainer or the detainee to show why they should be released to some extent. And under the Irving Act, the person that we're seeking to commit, well, the burden is on the district, I guess, to show why they should be committed civilly.
So under both scenarios, the burden of proof is on the district, but the onus under the IDA is on the individual to seek the probable cause hearing. And I don't think it matters. They're always represented. They'll be represented by counsel in the criminal proceedings, and generally they'll be represented by appointed counsel for the civil proceedings when the civil commitment petition is filed. So I don't think it is problematic that the onus is on the person. Regardless, the district bears the burden of proof, both for somebody who's brought off the streets under an FD-12 and for the probable cause hearing under 525, if that's straight under C2.
Unless there are any additional questions at this time from my colleagues, I'd like to hear from counsel for appellee.
Good morning, and may it please the court. Kelsey Townsend on behalf of the appellee, Wendell Macklin. I'd like to focus us back in on the plain text of the statutes. In every statutory interpretation case, that's where the analysis begins. And in this case, that's also where it should end. Under the Incompetent Defendants Act, as the government now concedes, detention authority ends with the commission hearing. Additionally, because the Department of Behavioral Health never filed an application for Mr. Macklin's emergency hospitalization under subchapter 3 of the Urban Act, they had no authority to detain him under the Urban Act. Because neither statute, by their plain terms, permitted Mr. Macklin's continued detention, and because detention statutes in every case must be read narrowly, this court should affirm the trial court's order releasing Mr. Macklin. Both statutes are very plain in their language and in their application here. And there's no need to go into legislative history to attempt to rewrite the statute, which is essentially what the government is asking for here. And the entire basis for that request is this idea that somehow there's a gap in detention authority here. And I don't think that's true. That's not true because the criminal court has ongoing detention authority in the criminal case to detain somebody. And the family court has detention.
I thought, although that it seems to be true as a statutory matter, I thought that you suggest that that may actually not ultimately be true because there may be constitutional problems with the purported grant of statutory authority for such detention.
That's right. We think there's facial constitutional issues with subsection A2. Most notably, as Judge Easterly pointed out earlier, there's no detention stand. There's no standard at all under the statute for when you're actually detaining somebody under that statute. I think that's a glaring constitutional issue. But regardless of the potential unconstitutionality, this court has never found it unconstitutional. It's on the books right now, and it purports to provide the criminal court with detention authority. But even if subsection A2 didn't exist, family court still has the authority to detain somebody if DBH files an application, an FD12, an application for somebody's emergency hospitalization. The government has never suggested that it doesn't have that authority, that it didn't have it in this case. They just chose not to exercise it. That's the only gap.
Can I interrupt briefly to ask a question for clarification? So what was the purpose? Because I thought to some extent the government, the initial hearing before the Mental Health Commission, which I was clarifying earlier, I thought might have been a probable cause, but it was the hearing before the commission before the criminal case was dismissed. What's the purpose of that? Isn't the purpose of that process to signal on the part of the government that this is somebody that we're worried about, may be a danger to themselves or others? So we want to put in place some process so that if, depending on how things go in the criminal case, we have some ability to reach out or grab into our system this person for further evaluation.
I don't think that's right, Your Honor, because that commission hearing is conducted in a standard civil commitment case, regardless of whether or not somebody has a criminal case ongoing. And it's also important to note that that commission hearing takes place in every civil commitment case, not just in emergency hospitalization cases. So if you have somebody who a 541 petition, a petition for civil commitment has been filed for, and like Mr. Macklin, there's no application for emergency hospitalization, regardless of the commission findings at that hearing, they're still going to remain at liberty.
So I don't see how under your scenario, then there is a way to avoid the inadvertent, improvident release of someone where the criminal case is dismissed and no emergency petition has yet been filed. Suppose the case is dismissed at 4 o'clock on a Friday afternoon. When, I guess timing wise, logistically, how do you see this statute working to avoid a situation where the defendant here is released on a Friday afternoon, is out all weekend until Monday when the district can file its emergency hospitalization petition. And then the worst fear, which if you read some of the legislative history, is that this person then commits a dangerous crime.
So I have two responses to that. First, in this case, there was a motion for Mr. Macklin's release that was pending for some time. And I think that's going to be the case in most situations where the government's going to be on notice that release is being requested, so they can prepare to file an application immediately upon a release decision if necessary. But secondly, as we were noting earlier.
Before you go to the second, what do you mean exactly about the first? So I'm the lawyer for the government, and I know there's a motion. I think, well, I'm not sure what the trial court will do. I've prepared my document, but then the court issues a release order. Is the idea that that release doesn't happen right away, and I say, wait a minute, judge, I've got something I want to file. But I mean, is your view that such a document, if filed like immediately, would preclude the actual release by the criminal? I mean, I'm just not quite sure how it works practically. And it seems like it'd be more, you'd be concerned that you wouldn't be able to get filed whatever you need to get filed so that someone didn't get released before the new thing you file quickly after the order releasing them takes effect. So it might really compel you more to take a preventative measure and start it up out of concern of release. But you think your view is it's enough to have it prepared, because before the release in the criminal case could get implemented, you'd be able to take the steps to preclude a gap in custody?
Right. Well, so first of all, the application isn't the petition that's filed with the court. The application it's expressed under subsection 521 that it allows you to take somebody into custody without a warrant, without court authorization. So yes, all you need is the form. But also,
again, just to make clear, I get that, and that's an important clarification the way I was wording things. So it's a very fair point. But I guess if there's a motion that has been filed that might result in the release of a person, and I don't know if that's going to happen. I don't know when it'll happen. The judge could just issue an order on whatever day, and then all of a sudden the person is released in the criminal case. And if I have, so I have authority, I guess, in theory, to, if I think I have all my ducks in a row, I have authority to actually take that, to cause folks to take that person into custody and begin the emergency hospitalization process. But I don't know when to start that. I mean, is the idea that I need to just have people waiting outside the jail or wherever the person's being, the mental health facility where the person's being held? I'm just not quite sure how any approach other than a preemptive filing approach is practical. But maybe it is practical, and I'm just not understanding why it's practical. But I would have some pretty significant practicality concerns if I wanted to make sure there was not going to be what might be the improvident release of someone who I might have reason to believe is an imminent threat to him or herself or others.
So I think it is practical. I think it was done in Peterson. It's been done since the decision in this case. But if you'll allow me to go to my second point, something that was raised here, because when the criminal judge was releasing Mr. Macklin, she faced the question of whether or not she had authority to release him outright or whether she had to remand him under subsection C1, and came to the conclusion that because subsection C1 contains mandatory language when it's referring to the remand, that she had to remand him to the inpatient facility, and that it was up to them at that point to release him. And I think that that's a reasonable interpretation of subsection C1, although this is a unique case, that it permits for a mandatory remand, but that then it's up to DBH to release the person at that point. So I think that was the main purpose of these provisions, is to prevent people from being released onto the street outright, but not to shoot them into the Irvin Act, which is an entirely different beast.
Sorry, I was muted.
No worries.
I'm confused. because we're talking about a Jackson's defendant, right? And there's a process for the defendant to be found not competent and not likely to become competent in the future, right? So that takes some time, arguably puts people on notice that this individual has mental health issues. The person, 24/5/3105 talks about competence treatment, their hearings during the competence treatment. And it's only under 24/5/3106, sub C sub 4, right? That you get to the end of the road with competence. And if the court finds that the defendant is incompetent, the court can either release the defendant or, where appropriate, enter an order for treatment for up to 30 days pending the filing of a civil commitment petition, right? And then can order treatment pursuant to 53107A2, which we've discussed, for such period as necessary for the completion of civil commitment proceedings, right? So automatically there, sort of the likelihood that someone who's been Jacksoned is going to be immediately released into the street seems to be addressed by 24/5/3106C4 and 24/5/3107A2, no?
Well, that's assuming that the criminal court is holding them. I mean, I
Right,
think
but I thought that's where we were, was sort of like, oh my goodness, what if we've got a Jackson's defendant and there's some concern about their mental, I mean, they're already determined to have been mentally ill, and that's affecting their competence, but there's some concern that has not really crystallized about their potential dangerousness. And so civil commitment might be on the table. These provisions that I just discussed directly take you into those and allow this individual to be held so that the civil commitment proceedings can be initiated, right?
right.
Not the emergency, but pending the filing of the civil commitment petition, this individual can be held, right? And then
Correct.
only if you get to 53107A2, where the court decides to release the individual from criminal custody, do you get to C1, where it says, if the court orders the person in the criminal case to be released, the court shall remand the person to the inpatient treatment facility, and the inpatient treatment facility may detain them. Now, as I noted earlier, it's a may detain language, but still it's indicating that the expectation is this individual is not being released out onto the street with the termination of the criminal court custody, right?
Right. I think we're talking about a situation like Mr. Macklin's, which is unusual, but in which the commission hearing has already taken place.
Can I ask
So,
you how
so that may detain authority doesn't apply.
Right.
And
can I ask you
Right.
how it works?
But in Mr. Macklin's situation is so unusual that it's not terribly helpful in sort of figuring out how the statute would ordinarily work. And that's why I think that it's helpful to walk through the Jackson process, right? Which is thoughtful and deliberate and has hearings, and people can kind of see where it's going before it gets there, right? And then plan accordingly and file the civil petition and proceed in that manner. And it seems like there's an awful lot of time to file the emergency petition, but maybe I'm mistaken about that.
no, I think that's exactly right. I think this is a unique situation where somebody might have to show up with an application in hand, but in most situations, it's very clear beforehand when somebody is going to be released.
can I ask you how you think it operates in particular C1 and C2 of 24-53107, how they operate in the more typical case? Because I have to say both parties are arguing that the text is unambiguously clear in their favor, and I find myself more confused than either of those positions suggest. So imagine a setting again, there's been a determination that the person is unlikely to regain competence, and the trial court has decided not to hold the person in the criminal case, and therefore remands the person to inpatient treatment facility, and there hasn't yet been a hearing. A petition has been filed. There hasn't a civil commitment petition has been filed. There hasn't yet been a hearing. And imagine under C2. So I think if I understand it, your view is, again, maybe there are constitutional questions about how that should operate in some settings, but the statutory provision permits detention without any further finding up until the point of that hearing, except as provided in C2.
Correct.
And so C2, so imagine that that's happened, and the defendant's lawyer right away files a request for a probable cause hearing for the person's continued detention. Well, the statute says that that is going to be a hearing. I guess the hearing is pursuant, or the detention is pursuant to section 21-525. And what do you, on your understanding of how these statutes work, what is the purpose of that probable cause hearing? And I mean, there are really three questions. What is its purpose? What are the standards that should be applied? And what is the legal consequence of the judge's ruling? But how do you understand the function of that hearing under your reading of the statutes?
So what I understand C2 is doing overall is providing a limitation on the authority that is granted under C1. So C1 is providing for detention authority that doesn't exist under the Irvin Act, right? Because we're talking about people who haven't been emergency hospitalized. So this is a person who under the Irvin Act would not be detained. C1 is saying, well, because they're coming in through the criminal court through a criminal case, you can detain them up until a commission hearing. C2 is just a limitation on that detention to try and meet the constitutional minimum of that detention authority. In other words, a person who's detained up through the commission hearing, of course, has an opportunity to challenge that detention and say, well, there's no basis to detain me at all. But to read.
So what happens? So what is the judge supposed to decide? Probable cause. What are the probable cause determinations that are contemplated by that hearing?
So I think it's worth noting that this court has never actually held that the emergency hospitalization standard would apply in that context. I think it's likely the only standard that could meet the constitutional threshold for this detention provision.
Well, and does your client have a position about what, on your understanding of the statute, as you're trying to persuade us to accept your view of it, what is it you want us to understand that statute to require by way of a probable cause hearing when it is invoked?
So I think the only standard that could possibly apply at that point is the emergency hospitalization standard, because there's no basis for somebody to be detained in the criminal case because.
I assume that's true. And imagine at the end of that hearing, the judge says, I find probable cause to believe this person is a danger to himself or herself and others, and an imminent danger, and inpatient hospitalization is the least restrictive alternative available. What is the legal consequence of that order if it's entered? Does it authorize detention thereafter under the Irvin Act?
No, it authorizes detention under C1. So, I mean, C2 says a person so detained, meaning a person detained under C1 through the commission hearing. So if the court makes a finding at that probable cause hearing that the emergency hospitalization standard is met, that there's grounds for a person's detention, that authorizes their detention under C1, which by its plain terms terminates with the commission hearing.
And then, so the logic of your argument is that, I guess, with respect to the ordinary kind of a case in which the trial court, invokes the provisions of C1 and there hasn't been a hearing yet, and the defendant says, well, I'd like a hearing because I don't think I should be held at all. And the trial court holds a hearing and says, No, you should be held. I'm making the findings that authorize your detention under the Irving Act. Your view is that's kind of good only until the commission hearing, and that what also has to happen in parallel, notwithstanding that that finding has already been made, is that the government needs to file an emergency petition, and a bunch of things that are kind of antecedent normally to that judicial finding have to be done. And then you need to have a new judicial finding on the exact same issue after that additional process. Is that how you are arguing that the statutes fit together?
Well, I mean, that's what this statute says, right? It says detention ends with the commission hearing. So if
to me, it's not entirely, it certainly doesn't expressly say that. The issue is how to read these provisions as fitting together. So,
but there's no, I mean, I think that the critical point here is that the plain language is the best indicator of legislative intent. And what you see when you look at .07 as a whole is that the legislature knew how to write ongoing detention authority if they wanted to. I mean, 2 subsections earlier in A2, they provide the criminal court with detention authority throughout the pendency of proceedings. And they also know how to cross-reference different subsections of the Irving Act. They cross-reference 541, 525. And so if they wanted to say—
To be clear though, your view is, because you made a legal argument in support of a conclusion, which is fine, but am I right that to characterize your position as I did, which is in the ordinary case where there is a hearing pursuant to C2 that is then pursuant to 525, and the judge makes findings that would suffice to hold somebody substantively under the Irving Act, that doesn't authorize any detention beyond the commission hearing, whatever the commission also finds. And instead, there needs to be an emergency petition, some steps that are usually antecedent to the judicial finding required by 525. And then there needs to be a new judicial determination pursuant to 525, driven through the process of that emergency hospitalization application. Is that a correct description of your view about how the statute operates?
Yes, but I'd qualify it in a couple ways. First of all, a substantive finding that somebody meets the standard for emergency hospitalization isn't enough to hospitalize them under the Irving Act. The procedure is the very core of the act. So, and this court made that clear in Deloach and Reed, where certain procedural requirements weren't met, but then a probable cause hearing was held and a person was found to meet the standard. And the court says that's not enough because the substantive standard doesn't get you to detention under the Irving Act, the procedures do.
I get the point that procedures are really important. That's a very fair point. But what finds me what I find fundamentally puzzling about this case, and I should say I have a hard time understanding the statutes, as clear for either side, is it seems to me really odd if the legislature's view was, we're only going to have you detained temporarily pursuant to these bridge provisions, as which is, I think, a reasonable shorthand. And if there's going to be anything other than detention beyond the point of the commission hearing, you need to go back to the beginning of the emergency hospitalization process and start from ground zero. If that's what the legislature meant, it just seems really odd that instead they send you to 525, which sends you to 524, which seems to be in the middle of things rather than back to the front of things. So it just seems strange and confusing and unclear that they instead send you back in an odd way. They say, pursuant to 525, 525 says give a hearing to somebody whose hospitalization is ordered under 524. Well, these Jackson defendants are not people whose continued hospitalization is ordered under 524 yet. That's not how they got to where they are. They got to 525 from the IDA. And so it seems like they do kind of drop IDA defendants in the middle of things rather than contemplating they'll go all the way back to ground zero. And that's what I find confusing about the statutory structure and language.
I mean, I think that assumes that there was an intent to shoot someone over to the Irving Act at all, which I don't think is clear under the language. I think the part that references section—
Just to be clear, I mean, it says have a hearing pursuant to 525, which is a part of the Irving Act.
Right. And I think what the what that subsection was doing is indicating really that this is a probable cause hearing and that it's one that's going to happen in family court, where there are psychiatrists, where the court is sort of used to having these types of hearings, rather than having this hearing in criminal court, which would be quite odd since the criminal judge had just decided to release someone. So I think all that's doing is picking, a hearing that happens in family court under the Irvin Act and saying, and to meet our constitutional minimum of providing this extra detention authority that doesn't exist under the Irvin Act, we'll give you this probable cause hearing. But I don't think that indicates any intent to put someone into the Irvin Act, whether at the middle or the beginning or the end. And if the government wants to detain somebody under the Irvin Act, of course they have to start at the beginning of emergency hospitalization, because a person who's been found to meet this standard is met under the IDA. They're never held under the Irvin Act.
All right, anything further, Ms. Townsend?
I'd be happy to take any additional questions from the court. If not, I would encourage the court to follow the plain language of the statutes here and affirm the trial court's order.
All right, unless either of my colleagues have any additional questions, we'll return to Ms. Johnson and allow her a couple of minutes of rebuttal.
Thank you. I will try to be brief, but I have about 5 separate points that I want to address. The first is simply a correction from my earlier argument. I had referenced the Reed case for establishing the standard for the probable cause hearing. It's the Barnard case. It is cited in my brief. Number 2, opposing counsel has mentioned that the district will have time to put together an FD-12 and petition for emergency hospitalization because, of course, the person will have to file a motion for release. This is simply untrue. The reason Mr. Macklin had to file a motion for release is that at that point, the Superior Court had been consistently interpreting the transfer provision, the bridge provisions in the Irvin Act in the manner that the district encourages, and the matter was unsettled. If this court affirms the Superior Court's decision, then detention authority will expire, absolutely expire at the conclusion of the commission hearing. No motion will need to be filed, and the district will, if an FD-12 has not yet been filed, have to scramble to do one in that quick time. Now, in Peterson, this court rejected that type of an approach and found it dangerous. All right. Third, and I think this is also important, it appears that Mr. Macklin's biggest concern and the Superior Court's concern is the possibility of a standardless detention. And that seems to be the big fear. But the Superior Court's interpretation increases the likelihood of a standardless detention. For the period of time between the release from criminal custody and the commission hearing, if the district or whoever the hospital is does not start the emergency hospitalization process under the Superior Court's interpretation, that hospitalization is not under the Irvin Act, and there is no standard. It says the hospital may detain the person, but it doesn't establish a standard. If this court adopts the district's interpretation, that standard is immediately incorporated. Finally, the idea that the first 3 steps of the Irvin Act, that the earlier of emergency hospitalization, that the procedure is at the core, only enhances the district's interpretation, because that procedure is ordered in order to bring somebody into custody in the first place. And if this court looks to the Herman decision, also cited in my brief, what the court has held is, okay, the timing of procedure, those very strict time deadlines to make sure that somebody is not held for more than 72 hours without a court looking at their detention, those require immediate release if you fail to accomplish them. But if there are other problems with the early procedure, say the person who signed the FD-12 wasn't a qualified doctor, then the probable cause hearing cures that defect. The probable cause hearing is the heart of the emergency hospitalization. Finally, just as part of a plain language argument, I think it's helpful to look at the difference between the IDA's use of the words pursuant to versus the IDA's use of the words consistent with. So Because the pursuant to Section 525 language is, we believe, the core of the plain language interpretation we are encouraging. Now, the IDA uses the words pursuant to in a lot of places. Most of them refer within the statute, so it's pretty clear what they're talking about, but some of them do refer to other statutes, maybe the juvenile statutes, maybe the statutes involving people with intellectual disabilities, and the Irvin Act. And from context, every time they say pursuant to another statute, they're not talking about incorporating the standards from that statute into the IDA. They're shuttling the analysis into that other statute. In comparison to, if you look at the IDA and you look at 0.09, and this has been the subject of a previous case cited in my brief called Taylor. In 0.09, the question had to do with involuntary medication of somebody who's being detained under this statute. And the petitioner in that case argued that because 0.09 says that involuntary medication can be provided consistent with the Consumer Mental Health Consumer Bill of Rights, and because he was not a consumer under that statute, it couldn't apply to him. And this court said that the consistent with language meant that the procedures were incorporated into the IDA, not that we then would follow the entire Mental Health Consumers Act. So I think that the pursuant to language does provide, and in fact gives this court, and of course, this court's hesitation is understandable on this plain language, but I think that the best reading of this plain language is that the pursuant to Section 525 means we are jumping into that statute, and that that's the statute that controls.
All right. I'd like to thank both counsel for your briefs and arguments, and appreciate your engagement with us around the many questions we've had about the interaction of these two statutes. And you're free to exit our virtual courtroom at this time. We still have one argument remaining. All right. Good afternoon, counsel. This is our third and final case for oral argument today. Rose versus United General Contractors. Counsel, are you ready to proceed?
Yes, Your Honor. I am ready to proceed.
Thank you. All right, Ms. Clark, if you could state your name for the record and just let us know if you'd like to reserve any of your time for rebuttal.
Yes. For the record, my name is Denise Clark. I represent the appellant in this case, Todd Rose. And Your Honor,
I'm sorry, Ms. Clark, I'm having a great deal of trouble hearing you.
I will speak up a little bit louder and get closer to the microphone. Okay. My name is Denise Clark. I represent the plaintiff. I'd like to reserve 3 minutes of my time.
All right, thank you.
Thank you. In 2013, in Sparrow versus the District of Columbia Office of Human Rights, 74 Atlantic 3rd, 698, this court addressed how under the Human Rights Act, seeking an accommodation is protected activity. And in discussing it, the court pointed out the interactive process serves to identify potential accommodations that can overcome the employee's limitations. That employers participate in an interactive process by meeting with the employee who requests the accommodation, requesting information about the condition and what limitations the employee has, asking the employee what he or she specifically wants, showing some sign of having considered the employee's request, and offering and discussing available alternatives when the employee's request is too burdensome.
Ms. Clark, if I could jump in briefly on this point, which is one that I do have a couple of questions about. I thought that even while the interactive process serves the exact goals that you identified, it is an obligation on the employer to engage in this interactive process to determine if an accommodation is reasonable, but only where the employee has actually requested a reasonable accommodation. And as I read and understand the record, it's not clear to me where in this record a reasonable accommodation was requested by Mr. Rose, or what the request was for the reasonable accommodation.
Thank you for that question, Your Honor, because really when you go back to the statute of the ADA, which we're grounded there, the statute actually says that the interactive process actually starts when the employee informs the employer he or she has a disability. So the disability was known the entire time. At that point in time, the interactive process becomes one of where either the employee could say, yes, I have a disability and I need an accommodation.
So
Or
are
an
you saying that
employer,
the process started when they hired Mr. Rose?
when they
Does-
knew the process of the interactive process began when they knew of his disability. And
But
so
When they hired him?
I would say when they hired him, sure. That
Counsel, are you discussing this in connection with the retaliation point, or are you discussing it in connection with the discrimination point? Because if you're talking about retaliation, I mean, it may or may not be accurate that for certain purposes, the accommodation process begins as soon as the employer knows of the existence of a medical condition that might be a disability. But in terms of retaliation, there needs to be protected activity. So assuming that the accommodation process starts early, just with the employer knowing something, that wouldn't be a basis for retaliation. I mean, if I am an employer and I hire somebody and I know they have a disability, so you could say maybe the accommodation process has already started, and then I fire them, even though we've never had any conversation about it, they've never requested anything implicitly or explicitly. Are you saying that could be a retaliation? It could be discrimination for sure, but I don't quite see how it would be retaliation in the absence of some communication that was protected activity. Are you suggesting that, again, the employer knowledge is enough to be a predicate for a retaliation claim?
No, I'm saying that that's where the interactive process starts. So let's separate the two issues. There's the discrimination claim and there's the retaliation claim. Since you've raised the retaliation claim, Your Honor, I'm gonna go there directly. Retaliation claim in this case, I think, really starts when there is a request to the plaintiff, to Mr. Rose, go and get the information. We want to know from your physician what you can and cannot do. The background to that is the fact that they offered him this position to be a manager. He declines that position. And the next step is to start discussing what his capabilities are.
Right, but just, again, you're saying that the protected activity starts then, but I assume you don't think, I mean, but let's find out. If I'm an employer and I say, employee, I'm interested in whether there are any disability issues. And so I'd like to get some information about whether you have any medical conditions that are relevant to your job performance. That isn't protected activity. I assume that's a communication by the employer to the employee. I don't see how it could be protected activity. And it doesn't make any sense, but if I fired the person because I sent you that, I sent you a letter and now I'm going to fire you because I sent you a letter, well, that would make no sense. But you would agree that's not protected activity. It's a request from the employer for information. Or do you think that's protected activity?
First, I think you've started the interactive process, and that then his conduct of following your instructions to go get that information.
Well, I want to go step by step.
I understand.
Maybe more but do you agree that the letter itself from the employer was not protected activity here, that something more on your client's part was needed?
I agree. The letter by itself is not protected activity.
And let's just to go one step down, imagine that I'm the employer again, and my employee sends me a letter saying, when do you want it by? And again, it wouldn't make much sense, but let's say I fire my employee because the employee asked me, when do you want your letter by? Would you say that could be retaliation? Because that's
at that point, because at least it demonstrates, first, my answer is yes. And the reason I think it is because it reflects that the employee has heard the employer and is taking the step to go get what the employer wants. But it's much more than that in this case, because it's clear in the record that Mr. Rose spoke to his employer at least on 2 occasions about what he wanted. And we think that that's in the process of him trying to get the information that's requested, that he is engaged, that he is seeking to secure that information, and therefore he's engaged in the protected activity.
Are you talking about the 2 emails, or are you talking about other conversations previous?
I think we point this out in the brief. There was a communication on November 13th. And again on November 15th. Yes, I believe these were emails.
And those emails, one of them is, I mean, could you summarize each of those 2 communications, like what the gist of them is in your view? I thought one of them was in the nature of, what exactly do you want? And
yeah, and the other was in the nature of being clear about what the note needed to contain. Mr. Auber spells out what he wants in that note. Yes. So
again, the actions, assuming that the protected activity has to be actions by your client, it's 2 emails that are in the nature of, you've asked me for some information that might potentially be related to disability issues. And I have some kind of procedural questions for you about what exactly you want, when and how.
right.
I mean, if you were going to point us to, I mean, that seems very early on in the process and not really much of an implicit request for anything yet. It's more of a, you've asked me for information. I'm just trying to make sure I understand what you want from me. I mean, what if you were going to point to cases that treat conduct like that by an employee responding with procedural questions about an employer request is protected activity? What's the kind of most similar case that you found that would treat things like that as protected activity?
Now, I don't know that I've found a case specifically where those procedural questions were found to be protected activity. I think I've cited the case that where facts were very similar in Sparrow, where my client was engaged, Mr. Sparrow was engaged in protected activity, and as found by the Court of Appeals in trying to comply with the requests that were made by his employer.
So you would contend, Ms. Clark, that the trial court's finding that these earlier emails were not protected activity was a factual or legal error? Because the trial court ultimately found that the exchange or the delivery of the final letter to the employer was simultaneous with the employer's notice of termination, and therefore the protected activity did not occur prior to the termination.
Yeah, I actually think it's a legal problem. And Your Honors, in your questions to me this morning, we're talking about a very short period of time in this case, where he was terminated on, I believe it was the 16th of November. He was requested to get this information 3 days before. So this is not a situation where the employee is told by the employer, I want some additional information about your disability, and 6 months later, the employee complies with the request. I think, Judge McLeese, in that situation, factually, there's a big difference there. And I don't think I would have much of an argument to make about whether the employee had some expectation of being engaged in the protected activity. I think these facts are very different because he is attempting to comply, and I believe there was a deadline set to within that time frame to provide that information. And anyone who deals with a physician today knows you cannot get an appointment within 24 hours. It's very, very difficult. Usually you've got to seek that appointment within a couple of days. And he was able to get some information from his physician and provide it to his employer, albeit as his employer is handing him the termination letter. So I think in terms of reasonableness and expectation, I think that Mr. Rose was certainly engaged in protected activity at this point because he is trying to comply. I think Judge McLeese, if this letter, if the doctor's note had come a week later, I think it would, I think it'd be hard to say he's engaged in protected activity. I think the close proximation here, it makes it a very, I think that the case law, at least, and I am relying very heavily on Sparrow. I think the facts in that case and the facts here are very similar in terms of engaging in protected activity, engaging in the interactive process, and taking an adverse action all within a short period of time. And I think for those reasons,
and with respect to the two emails, at least, and whether they're protected activity, you said one thing that led me to think you might be making the following argument. I'm just curious whether you are. So I think I assume it'll be undisputed, but we can find out, I guess, that to be protected activity, there aren't any particular magic words you have to use, and that, like, implicit requests for an accommodation or the like can be protected activity. I thought at one point it seemed like you were suggesting something along the following lines, which is the backdrop of the communication from the employer and the two emails from your client is that everybody knew your client had a physical condition that would, might well be a disability and might well trigger a need for accommodations. And the employer, all of this is in that context, and the employer realizes that and sort of understands there's kind of there's an issue teed up now about accommodation, and the employer wants some information, and your client is responding. And if the employer ends up essentially terminating your client because of what the backdrop, the request from the employer, and the two responses from the employee allow you to infer was kind of an implicit request for accommodation, that could be protected activity. Was that the point you were trying to make about putting?
That's exactly the point I'm trying to make. And the backdrop in this case, which I think is really important, is that the company it goes back to this offer of moving from the Glazer field superintendent to the project manager. And I think this is very implicit here. I think that it was made in the context of observations that are talked about in the trial transcript of him falling, concerns about him on the job, the communication that they might need, their insurance carrier has some concern. I mean, all of those things were happening around the time they make this job offer that he ultimately says no to. Then we have the communications about problems on a particular project, and those projects and those emails are happening in July and August. So once that occurs, I think that gave the employer a chance to make one of two decisions. They could have certainly terminated him based on those communications about the problems on the project, or they could have sought to continue to engage in this discussion about do something else. And they just weren't direct with him about it. They instead of just washing their hands and terminating him for a legitimate, what appears to have been in July and August, a legitimate reason, they start this, go get us some information about your conditions. Go tell me what you can and cannot do. He's engaging in that in good faith, believing, oh, we're still going to work together. My job, or some level of my job, is still protected. I'm going to go get this information immediately and give it to you. And instead, when he gives it to them, he's immediately given this doctor's this termination letter. And I think in that context, that's where his protected activity it's crossing with the engaging in this interactive process about what is or is not happening. And I think the employer just basically cut off that interactive process by terminating him that day. So yes, I think that's what occurred. And my time is run out.
Well, I was hoping you could we spent most of our time so far talking about the retaliation claim, but I was hoping you could go to your second argument as well about the termination based on his Parkinson's diagnosis. I guess is your argument that he was terminated wholly because of his disability or partially because of his disability?
I think it was wholly because of his disability. I mean, at the time that the termination occurred, there was no communication about any of the problems that occurred in the summer. So the letter that he receives, it doesn't even say it's a termination letter. It actually says we're letting you go because of work. We don't have enough work for you. All right. So that's the first thing. The second thing is within the context of that letter, they say it, none of this is your fault. We have to let you go. None of this is your fault. And then,
well, but they do say they list a number, I guess, in the testimony.
In the testimony, correct?
Yes, they indicate a number of reasons. And you know, I don't know which way the offer of the project manager position cuts, because I think there's an argument that it cuts in a way that's favorable to the employer. They valued his expertise, and they were having problems, fairly significant problems with the decline in his work performance. And
there's no discussion.
But just a minute, we see initially when he starts, they're very complimentary of the work, but then there are delays, there are miscommunications, there are gaps where the work is not getting done, and there are the instances of him falling. And the trial court goes pretty extensively into the record of these problems with the performance. And so then they make an offer, and as I understand it from the record, it was a lateral offer, same amount of compensation to a project director. And maybe you want to talk more about that, but that's how
that's disputed. That was deeply disputed.
But I don't know that maybe it was disputed before trial, but it seems that I don't know how my understanding is that the trial judge determined that was not a demotion.
Yeah,
was not a demotion, and so it seems like they are doing exactly what you say they should have done. They're doing it. They made this offer, and the performance continues to decline. And
no,
then we
offer, Your Honor, I dispute that. There's nothing in the record that says after the offer was made that the job performance continued to decline. There is nothing in the record in the trial.
Well, I thought, I mean, I don't know about continue to decline, but there is information about the date of the job offer, the project manager offer,
Yeah.
and then there are the emails and other communications about problems in performance.
That's correct.
Either all of which, almost all of which, are after the offer of the job,
Exactly.
the manager position.
Yes, and that was the point I made earlier. Prior to the discussion about the project manager position, there were no problems. No problems communicated. All of those problems occurred after he declined that position. And
I feel
offer was
confused.
July 17th, and the first email about the problems was July 31st, and the
Right.
next was in August.
No, there were indications that he fell prior to the time.
Again, that's a disputed fact. There's nothing in the record that shows any email about him falling. Those are statements that were made, and
Right, and those were credited by the trial judge as favorable findings, right? And we're at the bench trial, because there were disputed facts at the summary judgment.
Credited the testimony, correct.
I'm sorry, so there were disputed facts at the summary judgment level, which is why it went to a full-blown trial, bench trial. And the dispute.
Your Honor, let me correct myself. In the appendix, page 805, number 32, the court does not credit testimony that all concerns raised in emails fell outside. I'm sorry, I'm misreading strike that. I'm misreading that email. that particular line. I don't see anything about him crediting the following.
But there were complaints in email complaints in June of 2017 sent to your client, among others, and responses about problems that were going on. And then the conversation about project manager, I think, is a couple weeks after that. So there's at least some complaint
June
about
28th, correct.
So, I mean, again, I know there was a dispute in the trial court about whether there really were job-related performance issues. Your difficulty here is that the trial court ended up crediting that there were serious job performance issues and concluding, essentially as a matter of fact, that the job I'm a little unsure, reason for your client's discharge was the job-related reason. So unless that finding is clearly erroneous, I'm not sure how you can argue here that your client was terminated solely for discriminatory reasons rather than job-related performance reasons. Did you argue in the trial court, or have you argued here that this is kind of like a mixed motive case where although there might have been legitimate job-related reasons, the statute was violated because, you know, there's an additional, at least contributing or substantial factor was discrimination on the basis of disability? Have you made the kind of mixed motive sort of argument that sometimes is made?
I don't know if it was made in the trial court because I did not handle the trial. I don't believe that there was a mixed motive argument at summary judgment. But I do.
Do you understand yourself to have raised that issue in your briefing in this court?
I think that those arguments are made, possibly primarily in the reply brief. I don't know that it's necessarily made in the opening brief. I'd like to go back to the court's crediting the job performance issues at the time and the timing of the decision to terminate Mr. Rose. I accept what you're saying for purposes of argument. He had job problems in June, July, August. If that's happening, and I accept that for purposes of argument.
Ms. Clark, I didn't mean to interrupt you, but I just wanted to clarify in responding to my question about how we interpret the offer of the project manager. I had indicated that there were some findings, factual findings made by the trial court about job performance issues prior to that offer. And so that's where you're beginning.
Yes.
Thank you.
So, thank you, Your Honor. So if I were to accept those as known, as Mr. Todd know, as Mr. Rose knowing those, and then it raises a question about motive and timing. Why offer the job manager position, the project manager position? And two, why start an interactive process in November? If you know in June, July, August that there are problems, if you are being the benevolent employer that you appear that you want to be and offer him a position out of the field and he says no, then why aren't you telling him we can no longer employ you in this position because of job performance? Why then engage in the interactive process to get information about what he can and cannot do? Expressly tell him to go out and get a medical note, engage in, from our perspective, protected activity, and then turn around and terminate him. The timing of this is very suspect.
Would you argue then that the employer was obligated to offer the project manager position again, even though Mr. Rose had previously declined it?
I would, Your Honor, and I think in the context of the following, that if you're going to engage in this process of finding out what an employee can and cannot do, if you valued his expertise as they apparently did, and the court gives some credibility to that point, why not be very direct with him and explain, this is the job we can employ you in, this project manager position. We cannot employ you in the field any longer. If you cannot take this job, we have concluded you cannot perform the essential functions of a laser superintendent, but we believe that you can complete this position as a project manager, and make it very clear to him that the decision not to accept that position is essentially a decision to not work for the company. And I don't believe that the record is clear at all that they were that direct with him about what was going on and the reasons it was going on.
Thank you. And so Judge McLeese raised the question of the mixed motive, and I was getting at that notion as well when I asked whether you thought this case with the employer's decision was based wholly on his disability or partially. And your view was that it was based wholly on his disability.
I still believe that. I mean, I understand that they have documented reasons, business reasons for doing it, but I think the failure to directly communicate with him, and I understand that there are some emails that he was copied on. I don't think anyone ever turned to him to say, you are wholly responsible for this. We consider this to be a failing on your part. We are talking to you about the project manager position because we no longer think you can work in the field.
Thank you. Unless my colleagues have any further questions for you at this time, Ms. Clark will turn to Mr. Favors and we'll reserve your 3 minutes for rebuttal.
Thank you. May it please the court, Rashad Favors on behalf of appellees. And I just want to start by addressing that last point that opposing counsel made with regard to being direct with Mr. Rose concerning his ability in the field. And there is an email in the record that says just that. It's from Bob Arbor, who is a UGC employee, to Nate Lewis, who is the owner of UGC. And it starts by saying that I just finished talking with Todd about safety and being on the project. He has agreed that his time in the field full-time has come to a close. We discussed.
I'm sorry, where is this one in the records that you're reading from?
This is an email in July 17th, 2017 email. And this is concerning the project manager position. And the email is coming from a UGC management official concerning Mr. Rose. And he's saying that he just talked to him about safety and being on the project, and that Todd, or Mr. Rose, has agreed that his time in the field full-time has come to a close.
Do you have, I have a couple different emails, but do you happen to have the page in the appendix where that email comes up?
I do not have the page in the appendix cited in front of me, but these are included in the trial exhibits.
Okay.
I do apologize for that. But I did want to address that point directly. Another point that I wanted to address directly was concerning, and this goes back to the retaliation point, concerning the fitness for duty request. It was not the first time that November 2017 was not the first time that my client made a request for fitness for duty for Mr. Rose. That first request came in March of 2017. And it specifically comes in the form of Gilbane asking for, Mr. Rose's fitness for duty, any limitations that he may have. And so on March 1st, my client communicated this request to Mr. Rose, and kind of throughout from March to November, throughout that period of time, communicated that request in a number of ways to Mr. Rose, which culminated.
About the retaliation claim, since we've turned to that, and I guess I have a couple questions about it. One is the trial court, in discussing possible protected activity by Mr. Rose, refers only to the response, the doctor's letter. And the trial, as I saw it in the order, in its reasoning, when it says, here's why I'm not finding retaliation. And so one question I have is, the argument has been made in this court and was made in the trial court that there were the email exchanges were actually also protected activity. And so that the analysis of protected activity shouldn't focus exclusively on that doctor's letter and when it was exchanged and all. And I didn't see the trial court addressing that argument at all. So what did I miss it? Is there some place in the trial court's order where the trial court says, on retaliation, I understand the argument is being made that it's not just the doctor's note on the date of termination, what I'm finding to be the date of termination, but also these earlier email exchanges, and here's why I don't find them to be protected activity. Is that in the trial court's order somewhere and I missed it, or is it just not there?
Well, I believe he addresses it in some capacity by saying that he does give credit to, or he does not give credit that Mr. Rose made or engaged in protected activity via the November 13th and 15th communications.
Where is that?
That would, let me see if I can pull that up for you really quickly. Okay, I believe it would be, it's under the findings of fact.
Well,
Section in the order, and it is number 27 or 28. The court credits testimony that Mr. Arbor gave Mr. Rose a termination letter, and Mr. Rose gave Mr. Arbor the medical note on November 17th, 2017.
Yeah, I don't see how that has to do with the earlier communications were protected activity.
So it doesn't look like the trial court addressed those communications directly, other than saying that that Mr. Arbor asked Mr. Rose to provide UGC with a medical clearance note on November 13th, and that's number 26 under the findings of fact. But other than that,
what you do, I mean, if the trial court is returning a verdict on an issue, and there's an argument made to the trial court, oh, here's, this is protected, here I have two theories about protected activity. One is the response to the doctor's note, and the other is the emails before it. And the trial court in returning his verdict just doesn't say anything about one of those arguments. What is it you think we're supposed to do? Should we send that matter back for the trial court to assess it, or do you think there's something that we can do to nevertheless affirm?
Well, I don't believe that it's necessary to send it back to the trial court to address the matter, because the fact of the matter is this is a reasonable, the law states this is a reasonable accommodation request. Here, the company is requesting information from Mr. Rose, not the other way around. And so there's no request for reasonable accommodation from Mr. Rose. In fact, the first time that, either a limitation or a restriction is even mentioned by Mr. Rose is in that doctor's note that was exchanged simultaneous with his termination. And that's the first.
Why is the company asking for this information?
It's coming from their insurance carrier. And so
Well, I
that's
thought there was conflicting testimony about where I thought there were 3 or 4 different versions of why the company was asking.
well, there's an email from I may have misspoken, but there's an email from the contractor Gilbane requesting that Mr. Rose provide some kind of fitness for duty certification that came back in March of 2017.
Well, no,
But-
I think there was evidence that it was for insurance purposes. There was evidence it was to a request from the general contractor. There was some suggestion that it was driven by internal concerns about safety on the job. So there seemed to be a lot of different possible explanations about why it was being requested, all of which seem to connect to people's perhaps implicit understanding that there was a physical condition that might require accommodation.
Right. Well, I mean, specifically, it's not just, this is not just testimony. This is documentary evidence. There's an email that states just that from Gilbane stating.
Can I ask you, shifting over to the other aspect of the retaliation claim? So the main, I think probably it's fair to say the main argument that Mr. Rose was making in retaliation was, I gave them the doctor's note, which again is pretty implicitly, the doctor saying no physical labor. So it's a pretty implicit request for some kind of accommodation. And then I got fired. And the trial court's reasoning on that is puzzling to me. So maybe you can help me understand it. The trial court finds, as a matter of fact, it was disputed about when the termination decision was made. The trial court says, as a matter of fact, I credit the testimony that Mr. Arbor gave Mr. Rose a termination letter, and Mr. Rose gave Mr. Arbor the request for accommodations on the same day, not my emphasis, the trial court's emphasis. Therefore, the record doesn't show awareness. So the trial court's finding no causation. But many things that cause other things happen on the same day as the things they cause. So I don't quite understand why I'm not saying which happened first. I'm just saying they both happened on the same day. So I just don't think one caused the other. I don't get the logic of that. Can you help me with that?
Well, just with regard to this decision being made, again, there's documentary evidence to support that the decision was made at 6, or at least at the earliest 6:13 that morning. And this is prior to.
Well, there was somewhat conflicting evidence on the topic. And so what's going to be most critical, I think, is the trial court's findings and then the trial court's explanation of what those findings mean for its verdict. You think there's a finding? I haven't recently gone back to check rather than the analysis part of the trial court's ruling, which is what I'm looking at right now, the earlier findings. But did the trial court find, as a matter of fact, that the termination letter was given or was created or given to Mr. Rose before Mr. Rose submitted the doctor's note?
It says the trial court found that was submitted simultaneous. His termination and the letter.
Meaning more, the trial court said in the analysis section on the same day. You think the trial court simultaneous, like the exact second?
I don't think that they meant the exact second, but the same day. I think they were using that interchangeably.
And where's that? I'm looking back to I see that the finding that you read before, number 28, is that both things happened on the same day.
Right.
Is there something else that the trial court says more than on this, that's more than these two things happen on the same day? But if the trial court's reasoning is these two things happen on the same day, so I can't find that one caused the other, that seems like not very defensible reasoning, because again, lots of things, cause things to happen on the same day.
Well, I think that the trial court is making a credibility determination at this point. Beyond what they've put in the findings of fact, we've put Mr. Rose on the stand. We've put these various UGC officials on the stand to ensure that there was no causation between his termination and any request for reasonable accommodation or alleged request for reasonable accommodation. And so that's why I think that the trial court is comfortable in saying that, these things were exchanged on the same day or simultaneously.
Well, there are a number of different reasons that your client gives for why Mr. Rose is terminated. Some of the documentation, it says he was poor performance. That's what the trial court focused on. At another point, they were talking about there wasn't enough work, so his position was being eliminated. But then a week later, it was reinstituted, and someone else was hired. Or maybe it was a little more than a week later. That his termination had nothing to do with his poor work performance. That there were other financial considerations for the company. So it seems to be that there were a number of mixed reasons for his termination. Why was he terminated?
Ultimately, he was terminated because there was no more work, which is what the termination letter stated.
Right, but there was no more work as in his role in the field as a glazer. But then someone else was hired to replace him a very short time later, about a week or so, if I'm not mistaken. Isn't that correct?
That's what was alleged, but that's not what actually happened. I think Mr. Falcone came on maybe a month or two later. Then Ms. Rose, I would have to double check, but it wasn't a week.
Well, I guess even the trial court himself seemed to acknowledge that there were these work performance issues. That's what he focused on in his findings. But he seemed to acknowledge that there were all these other things out there too.
Sure.
And so that makes me wonder whether this really is a mixed motive case.
Sure.
And in which case, the trial judge really didn't address that part of it. And perhaps we need to remand for that to be addressed. What would you say to that?
Sure. And what I would say to that is that my client is a small minority-owned business who has never terminated anyone in its history. And that's approximately over 25 years. And what you see in the record is essentially them attempting to navigate a difficult situation in which they have their largest client, who is Gilbane, requiring a new position, this glazing field superintendent position that they've never had before. And then you have an underperforming employee with all these issues, Mr. Rose. And so what you see in the record is them attempting to navigate that situation to where, they like Mr. Rose, they value his experience, they like him as a person, and you see them trying to make it work by offering him, hey, well, it's not working out in the field. Let's give you a job where maybe you're not in the field, where we can utilize you better. We can maybe find a better fit for you. And then when that didn't work, and there continue to be issues, and the contractor is calling the president down to personally be at the job site. There was no more of a financial need for him to be there. The second thing I want to say to address that is that, the construction company varies from project to project, and one project, requires, 50 folks, and one project requires 10 folks. So it's a very, topsy-turvy business, to where, you're at this job site, one day, and the next day you're not. And so the industry in and of itself kind of lends credence to that fact that, at that point in time, there was no more work, and then work picked up again, at a later date, to where they hired another glazing field superintendent. And the third point and the last point I want to say to address that is that Mr. Rose seems to acknowledge, the topsy-turviness of the business and didn't generally seem to carry any hard feelings, mainly because he reached out to Mr. Arbor on Facebook after he was terminated to, see he was looking for work. And Mr. Arbor told him that it was none at the time, but, to kind of check back. And so there was generally no hard feelings. It seemed as if, that both parties, didn't, it was an amicable split, until obviously Mr. Rose filed suit.
So was this a mixed motive case under our legal standard where we need to remand it back to the trial court to look at the other reasons that may have been look at whether in part Mr. Rose was terminated because of his disability or his Parkinson's?
I don't believe this is a mixed motive case at all. I believe that this is a situation where, his job performance coupled with, financial reasons gives you a legitimate non-discriminatory business reason for the separation from Mr. Rose. Safety is a big thing in construction as well. I'm sure you can understand why. And so, certainly the falling down.
Well, can I ask you about the safety piece of it? Because the trial court, I thought, found as a matter of law in the summary judgment ruling that Mr. Rose was qualified for his position, the field position, not the desk job. And so that seems to be a determination that whatever his disability problems may have been, they did not interfere with his qualifications to perform his job. Do you, the safety point you're raising seems somewhat in tension with the trial court's ruling on that?
Sure. And so, on paper, Mr. Rose was certainly qualified. And I think that my client would recognize.
The trial court's ruling was just that he was qualified on paper. I assume that the trial court's ruling was he was qualified within the meaning of the DCHRA.
Sure. However, that does not mitigate him being qualified for a position, does not mitigate the job performance issues that he had. He had,
we were raising like health and safety issues, and that seemed to be a slightly different topic. Can I ask you, the trial court's reasoning in ruling for your client on the discrimination claim also is pretty abbreviated, and one part of it is definitely, I think, pretty clear and is an important part of the ruling and creates a significant obstacle for your opponent, which is basically to credit there were serious job-related performance issues. So the trial court clearly finds that. I think the record supports it. So I take that as pretty much a given for this case. But again, there can be mixed motives, or sometimes the reason for firing employees who are having job-related issues are not only them or not even them, but also other reasons that are precluded by law. And the trial court's explanation about the other evidence, and there was some, evidence that you don't often see in discrimination cases that supported Mr. Rose's side of the case factually, including, it's a pretty tough case to make if you send someone a letter which says, we're letting you go because of lack of work and has nothing to do with your work performance. And then your later argument is, no, the reason we fired him was because his work was just completely subpar. And then, today you said he was let go because of lack of work. That's a pretty, if you're an employee trying to make a discrimination claim, that's pretty good evidence for you that the employer has like 5 different reasons about why you were discharged. And some of them are contrary to documents that were filed and the like. So he's got some things on his side of the case, which the trial court sort of acknowledges in passing and says, well, it's true that there are conflicting reasons, but that doesn't itself necessarily show discrimination. That's true. But then the trial court puts a lot of weight on this thought that the chief judge's question is touched on, which is this offer of a position as a field superintendent. And the trial court says, I find it hard to believe that anybody who had any discriminatory frame of mind would have made such an offer. And I guess said, I'm not sure I see the logic of that. I think that the offer could be quite consistent with discrimination. I could see that it maybe points both ways, but I don't see why it's hard to believe that if, you know, I'm an employer and I think I've got someone with a disability, I'm interested in trying to get rid of that rather than dealing with accommodations and the like. And so I'll, you know, make an again, at the time the offer was made, there weren't really many work-related complaints. There was the one at least, but the more serious complaints didn't seem to have arisen yet. The trial court has said that as a matter of law, Mr. Rose was qualified for his position. Now, maybe because of stereotyping, or maybe because of frames of mind that are precluded under the DCHRA, the employer is saying, you know, I'm going to shuffle you off out of the field, even though that may not be warranted, really. And if you say no, then, you know, you're going to be no longer with us, and we'll start working on that process. I'm not quite sure why the trial court thought it's hard to believe that someone could make an offer of, you know, shunting somebody to a desk job could have a discriminatory frame of mind. I don't quite see the logic of that. Can you shed light on why? Well, of course, if they make that offer, it's just hard to believe they could have had any kind of discriminatory frame of mind.
Sure. And I think that, you know, the reason that the trial court believed that is because this was a lateral move. This was a move where he's making the same money. He still, you know, has the same, respectability, so to speak. He's in project management. He's a management official. And so, you know, I could see the logic if perhaps this was a demotion, but it was not a demotion. And so the trial court's thinking, I believe, is that, you know, why would if I were really trying to discriminate against someone, I would just essentially make it untenable for them to stay at the job. You know, this was a job where he's coming inside, he's making the same amount of money. There's no more hours, no less hours. And, you know, it seems to be a win-win for both sides. And so I think that contributed to that statement.
All right. Anything further, Mr. Favors?
No, Your Honor.
All right. Ms. Clark, we reserved a couple minutes for your rebuttal.
I won't need them all. And actually, it goes to this email. I did locate it. It's the appendix page 691. This is the email from Mr. Arbor to Nate Lewis and Casey Gwei, Gwei.
What was this page again? I'm sorry.
I'm sorry.
You said 691?
691 is the appendix page. Yes. If you look at the Adobe thing, it says 693, but I think this is at the bottom of the page, says 691. The email's dated July 17, 2017, and it's very clear that Mr. Arbor is communicating that he had spoken with Mr. Rose about safety and being on the project. That's exactly what he says. He then says he has agreed, meaning Mr. Rose, that at this time, that his time in the field full-time has come to a close. Not altogether, but full-time. Then Mr. Arbor represents, we discussed being a project manager and he is willing to make the transition, period. Then it says pay and benefits will need to be reviewed and agreed upon. So there was no, at the time they had the discussion July 17th, Mr. Arbor himself is saying that the pay and benefits had not been set. Then he says, it's a sad moment. I could see him starting to tear up. The next paragraph, I told him we really need to close up this project over the next few days. So that was the email that was sent. And
can I ask you then about what the trial testimony was? Because the trial court's order does go beyond that email and say the trial is a double negative here. It's just page 806, appendix 806. But the trial court says the court does not credit testimony that UGC did not propose, which I think means the court thinks UGC did propose. that Mr. Rose changed positions within the company and retained the salary that he received as a glazing field superintendent. Do you think that is just unsupported by the evidence because there's only that email and there's nothing else? Or was there trial testimony that the trial court there was crediting?
Your Honor, I did not handle the trial, so I don't recall, I'm not able to recall if there's trial testimony. I don't recall seeing any in preparing for this oral argument. So I can't give you an answer one way or the other. But it's clear at the time of the conversation between the two of them that there's no benefits that are set. I mean, he's documenting that on July 17th. And it's shortly thereafter that Mr. Rose is saying, no, I don't want this position. And so if there was further communication about, you know, it was going to be a lateral move or it will be a lateral move and you'll get to keep your salary, there's no email communication between them before the next email communication, which is to ask for him to go and get this medical information about his abilities. And so that's where, you know, that's where I guess consider that if even in that email communication, if Mr. Auburn still wanted to provide him with that project manager position, he could have said, hey, Mr. Rose, look, I offered this position to you. I'm willing to keep you at the same pay. But if you're not accepting this, we got to go the next step and I need to start looking at your, you know, I need to know more about your condition. I need to know whether or not you can perform the essential functions of the job. And that shows the continued discussion, and it would show, you know, that they were trying to keep him in the fold and not just simply we're done and let's just document this guy's going out. We have no intention of keeping him. And I think that's kind of a breakdown here. Unless the court has any further questions.
All right. We wish to thank both counsel for your briefs and your arguments, and we'll take the matter under advisement.
Thank you, Your
This
Honor.
court is now adjourned